of any individual litigant. We are saying in Article 370. I think that should resolve your problem.
Agreed. My request is only that, of course, I filed the first petition. I have a very serious issue with me. Permit me to argue in the last. I'm not saying allow me first. Permit me to argue in the last.
Yes, of course, Mr. Sharma. Yes.
You will be
Mr. Attorney, likewise, I think we don't have to, we will also request you, your side also to not overlap and then...
I will not overlap anything. I will not touch any point, whatever are going to be submitted by anyone over here. I have total different things.
Mr. Sharma, we got your point now.
Yes, you will be the last batsman. Yes.
Our but give me necessarily be based upon what is argued, what points are formulated, how, etc. And before they end, we would indicate our time. We have understood the concern that there should not be any repetition, unwarranted repetition, etc.
Yes.
May please your
point.
repetitions.
A point of clarification, Your Lordship. I was appointed to nodal counsel. Unfortunately, I'm not able to present as I'm down with conjunctivitis. But writ petition civil 1099/2019, in which Mr. Ramchandran was appearing, although two parties have withdrawn, there are other petitioners who are still prosecuting this case, and that there will be representation for that as well.
All right. Yes. Who will be appearing in that for the remaining petitioners, Mr. Prasanna?
We are still hoping that Mr. Ramchandran can come. There is
let us know as
difficulty that is.
Not Mr.
With regard to main petitioners, it's clear, but with regard to interveners, Your Lordship, nodal officer has given us time.
We'll see about the interveners. Let's first hear the council, and then we'll see what remains.
Already the issue, described by the Mr. Prasanna, the nodal officer.
But the court is to decide.
He has suggested the time frames. We'll see. Of course, we'll certainly decide at the end of the once we have a few of the leading counsel who make their submission. We know what areas still remain. We'll assign some time. Yes, Mr.
Sibal would be arguing which petition so that we can have that.
Doesn't it's in rate 370 now?
No, whom you represent, that's all, so that we can say the pleadings from
Mr. Loan.
Loan.
Yeah.
Please.
Akbar Loan. Anyway.
Yes.
Mulaz, this is indeed, Mulaz, according to me, a historic moment in many ways. First, Mulaz, that your Lordships will be analyzing why history was tossed out on the 6th of August 2019. Whether the procedure adopted by Parliament was consistent with what democracy stands for. Whether the will of the people of Jammu and Kashmir could be silenced in this fashion. Whether they will be denied a representative form of government through a diktat of the Union inconsistent with our Constitution. It is also historic because it has taken 5 years for your Lordships, Mullahs, to start hearing this case. And for 5 years, Mullahs, there has been no representative government in the state of Jammu and Kashmir. It is also historic because you will have to interpret Article 356 of the Constitution of India, an article which seeks to restore democracy. And how do that process? Through an article which sought to restore democracy, you have decimated democracy. Can that be done under Article 356? That the state of Jammu and Kashmir historically represented a very unique relationship, unlike princely states and the states of India which were integrated into the Union. Whether that historic relationship between sovereign authorities could have been jettisoned in this fashion by seeking to amend the Constitution and seeking to efface Article 370. Whether, Malaj, a governor of a state could have, on the 20th of June 2018, decided that I will keep the assembly under suspended animation, which is the power of the governor alone under the J&K Constitution, without even trying to find out whether they can form a government or not. Because on the 19th of June, a particular party withdrew support, and on the 20th of June, the governor passed this order. Whether on the 21st of November 2018, a dissolution of the assembly could have taken place before the imposition of Article 356. The governor on the 21st of June dissolved the assembly without reference to 356. And thereafter, Article 356 was used. And the manner that it was used will be Malaz. I will address your lordships on those issues. These are issues that will arise for your lordship's consideration, never raised, never decided by this court. So in that sense, too, it is historic. So Malaz, I will proceed because there is a historical context to the state of Jammu and Kashmir, Malaz. So I will have to take your lordships through that history. And if your lordships will permit me, Malaz, I'll start with the list of dates.
Mr. Sibal, as all council know that all the arguments, we have the benefit now of live transcription. So the arguments are being simultaneously, we have transcripts in the court on the basis of, speech to text software. Like in the Maharashtra case, by the end of the day, the transcripts will be given to the arguing counsel. Your juniors can just verify that there are no mistakes. If there are any corrections, they can be given to the registry so that we will upload them immediately on our website. So they are available for everybody then to, that will also help counsel who are following. Of course, it helps us as well as everybody else.
So Malaz, I'll start off with the list of dates, which is Malaz, volume 2, written submissions, volume 2, PDF page 33. Malaz, written submissions, volume 2, PDF page 33. We were reluctant students, but your lordships ensured that we become disciplined students. Yes, the list of dates, because it's somewhat elaborated, because it will give you a flavor what the issues are. May I? Yeah. With 33, Malaz, PDF page 33. It's called Appendix 1, List of Dates and Events.
It's of March 1846.
That's correct. That's correct. I hope it's 33, Malaz.
It's 33.
Yeah.
Okay. Fine. Yes.
That's options. Yeah, Malaz.
Written submission.
Malas, before this, may I want to make one statement clear, Malas, that we stand here on the premise that the integration of Jammu and Kashmir into India is unquestionable, was unquestionable, and always remain unquestionable. That was a given. And despite that, Mullahs, the whole structure was overnight, Mullahs, changed through a process which I will demonstrate was unconstitutional. When your lordships will be dealing with this matter, there will be 4 legislations in a sense that you'll be dealing with. One is the Constitution of India. The second is the Constitution of India as applicable in the state of Jammu and Kashmir. Third is the Constitution of Jammu and Kashmir. And fourth is Article 370. And the interaction between these 3 constitutions in the context of Article 370 is something that your lordships will have to look at as we move forward. But please keep that in mind. The reason why I say Constitution of India is applicable to the state of Jammu and Kashmir, that over time, there were several orders issued, constitutional orders from time to time, which were incorporated in the Constitution of India as applicable to Jammu and Kashmir. The result was that most of the powers most of the responsibilities and powers were actually in tandem with the Constitution of India. There was, in fact, really no difference other than Article 370 itself. All the laws were applicable, except that those laws were replicated in the constitutional orders of the government of India. Therefore, there was no reason to take away this right. It's in that context, Mullah, that I'm mentioning this. Now, Mullah, I'll go to the list of dates. On the 9th of March, 1846, the Treaty of Lahore was executed between Maharaja of Lahore and the British government, resulting in the transfer of certain territories to the East India Company, in particular under Article 4 of the treaty. The Maharaja cedes to the Honourable Company all its forts, territories, rights and interests in the hill countries which are situated between the river Beas and Indus, including provinces of Kashmir and Hazara. Earlier, Jammu's Maharaja Gulab Singh's General Zorawar Singh had invaded Ladakh in 1834. Ladakh came under Dogra rule and was incorporated into the state of Jammu and Kashmir in 1846. During the Sino-Sikh War, the Qing Empire invaded Ladakh, but the Sino-Tibetan army was defeated. Ladakh was claimed as a part of Tibet by Phuntstok Wangyal, a Tibetan communist leader. In 1947, partition left Ladakh a part of the Indian state of Jammu and Kashmir to be administered from Srinagar. On the 16th of March 1846, following the Treaty of Lahore, the British government executed the Treaty of Amritsar on March 16, 1846. Under the treaty, the hilly mountainous country with its dependencies situated in the east of River Indus and west of River Ravi, including Chamba and excluding Lahore was transferred by the British government to Maharaja Gulab Singh of Jammu. The reason was simple, Maharaj. There was a violation of the Treaty of Lahore, and therefore compensation had to be paid, Maharaj, to the British government. He was not able to pay that compensation. In lieu of that compensation, these territories were ceded. That's what happened. On the 30th of June 1857, Gulab Singh died and was succeeded by his son Ranbir Singh. Following the passage of the Government of India Act 1858, territories formerly in possession under control of the East India Company were vested in the British monarch in whose name India was to be governed. 1885, Maharaja Ranbir Singh died and was succeeded by Maharaja Pratap Singh. In 1889, 30th of August, the Interpretation Act of 1889 was passed by the UK Parliament. Section 18.4 of the Act defined the expression British India. All territories and places within Her Majesty's dominion, which are for the time being governed by Her Majesty through the Governor-General of India. In addition, the term India was defined under Section 18.5 as British India together with any territories of any native prince or chief under the suzerainty of Her Majesty exercised to the Governor General of India. You will note here, Mother, Jammu and Kashmir is not part of this. In 1925, Maharaja Pratap Singh was succeeded by Maharaja Hari Singh, the last ruler of the princely state of Jammu and Kashmir. And on the 20th of April 1927, the expression state subject was defined in the state subject definition notification dated April 20, 1927, which was issued by Maharaja Hari Singh. This notification classified state subjects into 4 classes and subsequently became the basis for the definition of permanent residents of Jammu and Kashmir under the Constitution of Jammu and Kashmir and Article 35A of the Constitution of India. Your Lordships need not go into it because we are not really dealing with that issue, but I'm just mentioning it. On the 22nd of April 1934, Maharaja Hari Singh enacted Regulation 1 of Samvat 1991 on April 22, 1934. Wherever there is Samvat, Malad, if you take away 57 years, that gives you the year. The regulation established a legislative assembly for the state of Jammu and Kashmir called the Praja Sabha. While certain legislative functions were delegated to the Praja Sabha, the ruler, Maharaja Hari Singh, retained supremacy over all legislative, executive and judicial matters. On the 2nd of August 1935, the Government of India Act 1935 was passed by the UK Parliament. The Act established India as a federation comprising governors' provinces, chief commissioners' provinces, the Indian states which had or would accede to the Federation of India. Under Section 6 of the said Act, the ruler of Indian princely states was empowered to execute an instrument of accession, declaring that he accedes to the Federation of India subject to the terms of such instrument. Under Section 2, an instrument of accession was to specify matters with respect to which the federal legislature would have competence to legislate for a particular state and the limitations, if any, on the federal legislature's powers to make laws or exercise executive authority over such state. Notably, as the state of Jammu and Kashmir was not a part of British India, provisions of the Government of India Act 1935 did not apply to it unless an instrument of accession was executed by its ruler in accordance with Section 6. On the 7th of September 1939, the Jammu and Kashmir Constitution Act 1939 was promulgated. While Maharaja Hari Singh retained sovereignty and supremacy over all legislative, executive and judicial functions, the Act provided the Praja Sabha to make laws for the entire state of Jammu and Kashmir or any part thereof, subject to certain conditions. Further, the said Act vested executive functions with council consisting of a Prime Minister and other ministers appointed by the ruler. The Act also provided for the High Court, which had been established by the ruler in 1928, to be a court of record with jurisdiction to adjudicate upon inter alia civil suits, civil, criminal and revenue appeals. On the 16th of May 1946, the Cabinet Mission issued a statement regarding its report. Under paragraph 15(1) and 4 of that statement, the Cabinet Mission plan envisaged a Union of India where the Union would have responsibility over defense, foreign affairs and communications, and the states would retain jurisdiction over all other subjects not ceded to the Union. On the 12th, 22nd of May 1946, the Cabinet Mission issued a memorandum titled States, Treaties and Paramountcy, which affirmed that following the establishment of an independent government in India, the paramountcy of the British monarch over Indian states would lapse and paramountcy power over their respective territories would return to the states. On the 19th of December 1946, the Constituent Assembly of India, in terms of the Cabinet Mission Plan, met for the first session. On the 22nd of January 1947, the Constituent Assembly of India unanimously adopted the Objectives Resolution, which declared the Assembly's firm and solemn resolve to proclaim India as an independent sovereign republic. Importantly, paragraph 3 of the objectives resolution declared that princely states that had joined the Union of India, and I quote, whether with their present boundaries or with such others as may be determined by the Constituent Assembly, and thereafter according to the law of the Constitution, shall possess and retain the status of autonomous units, together with residuary powers, and exercise all powers and functions of government and administration, save and except such powers and functions as are vested in or assigned in the Union. On the 25th of January, 1947, the Constituent Assembly adopted a resolution for the establishment of the Union Powers Committee to inter alia draw up lists of matters included in the and interconnected with the subjects assigned to the Union before the framing of the Constitution. On the 5th of July 1947, the Union Powers Committee submitted its second report to the Constituent Assembly. Significantly, the report noted in paragraph 3, and I quote, it is necessary to indicate the position of Indian states in the scheme proposed by us. The states which have joined the Constituent Assembly have done so on the basis of the 16th May statement. Some of them have expressed themselves as willing to cede wider powers to the center than contemplated in that statement. But we consider it necessary to point out that the application to states in general of the federal list of subjects, insofar as it goes beyond the 16th May statement, should be with their consent. It follows from this that in their case, residuary powers would vest with them unless they consent to their vesting in the center. And your Lordship knows whether that consent was given. The UK Parliament on 18th of July 1947 passed the Indian Independence Act of 1947. Under 1.1 Section 1.1 of the Act, from August 15, 1947, two independent dominions, India and Pakistan, were to be established. Significantly, Section 7.1b of the Act stated that following independence, the suzerainty of the British monarch over Indian states would lapse and return to the rulers of such states. Resultantly, as sovereign states, as many as 562 princely states had the choice to remain independent or accede to either of the two dominions established by the Act. Lastly, as a transitional measure, Section 8 prescribed that provisions of the Government of India Act 1935 would continue to apply to the Dominion of India and Pakistan subject to certain conditions. Under Section 9 of the Indian Independence Act, the Governor General issued the India Provisional Constitutional Order 1947, which made certain sections of the Government of India Act 1935 applicable to India, until other provisions were made by the Constituent Assembly. Among the applicable provisions was Section 6, which dealt with accession of princely states to India through the execution of the instrument of accession. On the 15th of August, India attained independence and was partitioned into the dominions of India and Pakistan. Further, as British paramountcy had lapsed, princely states that had not executed instruments of accession with either dominion became independent states. These included the states of Junagadh, Hyderabad, and Jammu and Kashmir. On 26th of October 1947, the ruler of Jammu and Kashmir made an offer of accession to India, asking for help from the Indian Dominion to meet a grave emergency caused by mass infiltration of tribesmen drawn from distant area of northwest frontier, coming regularly in motor trucks, Manshera-Muzaffarabad road, and fully armed with up-to-date weapons, which cannot possibly be done without the knowing of the provincial government of the Northwest Frontier Province and the government of Pakistan. In the instrument of accession signed by him on the same date, he declared his accession to India subject to the terms of such instrument. Under Section 3 of the instrument, the Dominion Legislature had authority to make laws for the state of Jammu and Kashmir on the subjects of defense, external affairs, and communication. Article 7 provided that the instrument of accession did not commit the ruler to the acceptance of any future constitution of India, while Section 8 vested sovereignty over subjects not acceded to India in the ruler. But there's just two issues I want to flag here. Your Lordships, in the course of this hearing, will have to determine what does a constituent assembly stand for. a constituent assembly stands for enacting a constitution for the future of the territories with respect to which the constitution is to apply. It's essentially a political exercise. It's not a legal exercise. It's a political exercise to take into account the aspirations of people, what kind of state the people want, and in the context of that, draft a constitution. Right? The constitution itself is a political document, but it takes into account the aspirations of several segments of society living within a united territory, takes into account their separate aspirations, and in the context of that, drafts a constitution to meet the aspirations in future years for decades to come. So the exercise of a constituent assembly is a political exercise. The drafting of the constitution, which is a political document, is a political exercise. But once the constitution is drafted, once it is come into place, then all institutions under the constitution are governed by the constitution. And those institutions are limited in the exercise of their powers because they have to exercise their powers consistent with the provisions of the Constitution. Parliament cannot convert itself into a constituent assembly. That's done. Today, the Indian Parliament can't say by a resolution that we are the Constituent Assembly. As a matter of law, they can't say it. Because they are now cabined, cribbed, and confined by the provisions of the Constitution. They can't pass a law which is outside the list. They can pass a law under 254. If the state passes a law, it's repugnant. They must adhere to the basic features of the Constitution. They can't suspend, except in emergencies with external aggression, the fundamental rights of people. That also is limited under provisions of the Constitution. The executive can't do things which are contrary to the law, and the judiciary then declares the law. But no parliament can convert itself into a constituent assembly. And if you accept that proposition of law, it has enormous consequences for the future of my country. And that is one of the most salient and, according to me, the core issues to be decided in this case. Because Parliament said that we declare the legislature of the state of Jammu and Kashmir as the Constituent Assembly. Where does Parliament get that power? How does Parliament get that power? Under which provision of law? Not under 356. No, just read. So that's, according to me, the core of the issue that your lordships will have to decide. May I now, with your lordship's permission, read the instrument of accession? Because what happened on the 26th of October, actually, the invasion, so to say, was started on the 20th of October. And within 6 days, these decisions were taken. Because the invaders came, they were armed, they had guns, they would have run over the state. The ruler realized that he cannot secure the security of his own people. He had entered into a standstill agreement with Pakistan. India refused to enter into a standstill agreement with him. And then, thereafter what happened? One second. Thereafter what happened was that he said, look, I need help, and he told Mountbatten, I cannot possibly secure my people. So thereafter, the proceedings started. He sought, and he said, look, if you help me, I will unconditionally access to India subject to my own conditions, which is separate millets from the instruments of accession of the other states. And India accepted it, and that's how India secured the peace and was able to millets. And of course, the precursor to that is the Ratcliffe Award, in terms of which millets the part of Gurdaspur, what connected Jammu Kashmir millets to India, was ceded to India under the Ratcliffe Award, which allowed for that contiguity, which was the basic principle on the basis of which the partition was to take place. So that's how all this happened. Now let me read to your lordships the instrument of accession. Huh? Volume 1, millets. Documents, volume 1. Yes. Millets, kindly come to PDF page. Yes. PDF page 7, offer of accession by Maharaja Hari Singh on 26th of October 1947. Okay. Documents, volume 1, PDF page, millets, 7. Yes, millets, volume 1, millets, page 7. PDF page is also 7.
I did not know that.
Exactly. How the leaders, because of the leaders, you can't complete. Yeah, that is the only thing. Right.
Page millets, 7.
Page 7 is an offer by.
Yes, offer of accession by Maharaja Hari Singh.
Begin with page 7?
Yes, page 7, 26th October 1947.
Mr. Sibal, you are referring documents volume 1.
Yes, volume 1. Volume.
Page 7. It's open with Treaty of America.
Yes. My Lord Mountbatten will do that later. I have to inform, may I, Madam? I have to inform Your Excellency that a grave emergency has arisen in my state and request immediate assistance of your government. As Your Excellency is aware, the state of Jammu and Kashmir has not acceded to the dominion of India or to Pakistan. Geographically, my state is contiguous to both the dominions. It has vital economic and cultural links with both of them. Besides, my state has a common boundary with the Soviet Republic of China.
And China.
It should be. And China, it should be. And China. In their external relations and dominion of India and Pakistan cannot ignore this fact. I wanted to take time to decide to which dominion I should accede. Basically, because he wanted to be independent, quite frankly. But given this situation, he had no choice. Or whether it is not in the best interest of both the dominions and my state to stand independent, of course, with friendly and cordial relations with both. I accordingly approached the dominions of India and Pakistan and entered into a standstill agreement with my state. Pakistan government accepted this agreement. The Dominion of India desired further discussions with representatives of my government. I could not arrange this in view of the developments indicated below. In fact, the Pakistan government are operating post and telegraph system inside the state. Though we have got a standstill agreement with the Pakistan government permitted steady and increasing strangulation of supplies like food, salt, and petrol in my state, to my state. Afridis, soldiers in plain clothes, and desperados with modern weapons have been allowed to infiltrate into the state at first in Poonch and then in Sialkot. There was a Poonch revolt, and finally in Mas area adjoining Hazara district on the Ramkot side. The result has been that the limited number of troops at the disposal of the state had to be dispersed and thus had to face the enemy at the several points simultaneously. That it has become difficult to stop the wanton destruction of life and property and looting. The Mahara powerhouse, which supplies the electric current to the whole of Srinagar, has been burnt. The number of women who have been kidnapped and raped makes my heart bleed. The wild forces thus let loose on the state are marching on with the aim of capturing Srinagar, the summer capital of my government, as first step to overrunning the whole state. The mass infiltration, tribesmen drawn from the distant areas of northwest frontier, coming regularly in motor trucks using Manshera-Muzaffarabad road and fully armed with up-to-date weapons cannot possibly be done without the knowing of the provincial government of the NWFP and the government of Pakistan. In spite of repeated requests made by my government, no attempt has been made to check these raiders or stop them from coming to my state. The Pakistan radio even put out a story that a provincial government has been set up in Kashmir. The people of my state, both the Muslims generally, have taken no part at all. With the conditions obtaining at present in my state and to the great emergency of the situation as it exists, I have no option but to ask for help from the Indian Dominion. Naturally, they cannot send the help asked for by me without my state acceding with the Dominion of India. I have accordingly decided to do so, and I attach the instrument of accession for acceptance by your government. The other alternative is to leave my state and my people as to freebooters. On this basis, no civilized government can exist or be maintained. The alternative I will never allow to happen as long as I am ruler of the state and I have life to defend my country. I may also inform Your Excellency's government that it is my intention to set up an interim government and ask Sheikh Abdullah to carry the responsibilities in this emergency with my Prime Minister. If my state has to be saved, immediate assistance must be available at Srinagar. Mr. Menon is fully aware of the situation and he will explain to you if further explanation is needed in haste and with kindest regards. Mullahs, Your Lordship, just a historical fact, at that point in time, Mullah Sheikh Abdullah was in prison. And he had been always, Mullahs, against the ruler because he wanted the will of the people of Jammu and Kashmir, Mullahs, and not a despotic ruler. So he was against the Sadr-e Riyasat, so to say. But Mullahs, when he realized that, look, unless I get him on my side, I'm not going to be able to defend. So he, Mullahs, released him and said, you form the interim government. Just a historical fact. That's how it happened. Yeah, no, I know that, but I don't want to bring politics into it. The moment I take somebody's name, they'll be the other side. No. Nehru had nothing to do with it. So I don't want to enter into politics here. No politics. I don't want fireworks in a very solemn occasion like this. Actually, the Ratcliffe Award. So, my lords, now the instrument of accession, page 9. Actually, your lordship knows more than we do. Your lordship knows more about it than we do.
No, we always keep learning.
There are, my learned colleague points out that there are very interesting snippets, the transfer of power documents as to how this happened, and VP Menon actually sets it out.
I just told them there were 7 miles from the Srinagar,
Yes,
the readers, when the army was asked to move.
absolutely, absolutely. Electricity, Malazus, everything. And they could not be controlled, they were raiders, so there was no choice. I mean, he never wanted to exceed, but there was no choice. So, Malas, may I, Malas, page 9. Whereas the Indian Independence Act 1947 provides that as, it's obvious, Malas, 15th August was independence. He did not immediately exceed. All the other Maharajas exceeded apart from those two, Junagadh and Hyderabad. He never wanted to. It's only in October that this happened. Whereas the Indian Independence Act 1947 provides that as from the 15th day of August 1947, there shall be set up an independent dominion known as India, and that the Government of India Act 1935 shall, with such omissions, additions, adaptations, and modifications as the Governor General may by order specify, be applicable to the Dominion of India. And whereas the Government of India Act 1935, as so adopted by the Governor General, provides that an Indian state may accede to the Dominion of India by an instrument of accession executed by the ruler thereof. Now, therefore, I, Shriman Inder Mahendra Rajeshwar, Maharaj the Viraj Sri Hari Singh Ji, Jammu and Kashmir Naresh, Tatha Tibet and Deshadipati, ruler of Jammu and Kashmir state, in the exercise of my sovereignty in and over my said state, do hereby execute this instrument. I hereby declare that I accede to the Dominion of India with the intent that the Governor General of India, the Dominion Legislature, the Federal Court, and any other Dominion authority established for the purposes of the Dominion shall, by virtue of this my instrument of accession, but subject always to the terms thereof. I need mark that. Subject always to the terms thereof, and for the purposes only of the Dominion, exercise in relation to the state of Jammu and Kashmir such functions as may be vested in them by or under the Government of India Act 1935, as in force in the Dominion of India on the 15th day of August 1947. Such functions that may be vested. I hereby assume the obligation of ensuring that due effect is given to the provisions of the Act within the state, so far as they are applicable therein by virtue of my instrument of accession. I accept the matters specified in the schedule hereto as the matters with respect to which the Dominion Legislature may make law for this state. I hereby declare that I accede to the Dominion of India on the assurance that if an agreement is made between the Governor General and the ruler of this state, whereby any functions in relation to the administration of this state of any law of the Dominion Legislature shall be exercised by the ruler of the state, that any such agreement shall be construed and have effect accordingly. In terms of this instrument of accession, my instrument of accession shall not be varied by any amendment of the Act or the Indian Independence Act 1947, unless such amendment is accepted by me by instruments supplementary to this instrument. Nothing in this instrument shall empower the Dominion Legislature to make any law for this state authorizing the compulsory acquisition of land for any purpose. But I hereby undertake that should the Dominion, for the purpose of a Dominion law, which applies in the state, deem it necessary to acquire any land, I will at their request acquire the land at their expense, or if the land belongs to me, transfer it to them on such terms as may be agreed, or in default of agreement determined by an arbitrator to be appointed by the Chief Justice of India. Nothing in this instrument shall be deemed to commit in any way to my acceptance of any future constitution of India, or to fetter my discretion to enter into an agreement with the Government of India under any such future constitution. Nothing in this instrument affects the continuance of my sovereignty in and over this state, or, save as provided by or under this instrument, the exercise of any powers, authority, and rights now enjoyed by me as a ruler of this state, or the validity of any law at present in force in this state. I hereby declare and I execute this instrument on behalf of the state, and that any reference to this instrument to me or to the ruler of the state is to be construed as including reference to my heirs and successors. And the acceptance your lordships will find at 11. I hereby accept this instrument of accession, dated this 27th day of October, 1947. Now, that's, sorry. Mothers, now there is a schedule to this accession, which is not in this document. But would my lords be kind enough to turn to document volume 4, PDF page 176. That has the schedule.
Volume 4 page?
Page 176, madam. PDF page 176. Running page 738, PDF page 176. Volume 4.
Running page 738.
738. Yes, 738. Yes, that's correct. That's correct. Your lordships might just remember the residuary power, Maharaj, unlike states in India, which vested under 97 with the union, vested in the state. Residuary power did not vest in the union, in the relationship of J&K with the union. So it was quintessentially a truly federal marriage, so to say.
Actually, the resolution, when it was passed by the Constituent Assembly, initially contemplated that the residuary power would be with the states.
Yes.
And it was between the time of that resolution and the eventual adoption of the Constitution that the residuary power under entry 97 came to the center.
But they all accepted it, Mullah, so that's. But here, Mullah, this issue was somewhat different. Now, Mullah, in the schedule, we'll find. Now, let's kindly see. That's correct. Yes. That's correct. That's correct. That's correct. Now, let's kindly see the schedule. Defense, naval, military, and air forces of the Dominion, and any other armed force raised or maintained by the Dominion, any armed forces, including forces raised or maintained by an exceeding state, which are attached to or operating with any of the armed forces of the Dominion, naval, military, and air force works, administration of cantonment areas, arms, firearms, ammunition, explosives, and external affairs, like implementing of treaties, agreements, other countries, extradition, including surrender of criminals, accused persons, or parts of His Majesty's dominions outside India, admission into and emigration and expulsion from India, including in relation thereto, the regulation of the movements in India of persons who are British subjects domiciled in India, or subjects of any exceeding state pilgrimages to places beyond India, naturalization, then communications, post and telegraphs, including telephones, wireless broadcasting, like phones and railways, etc. We need not go into this. Maritime shipping, navigation, port quarantine, major ports. And then Millard's aircraft, lighthouses, carriage of passengers, and then ancillary elections to the Dominion legislature subject to the provisions of the Act and of any order made thereunder. Offences against laws with respect to any of the aforesaid matters, inquiries and statistics for the purposes of any of the aforesaid matters, and jurisdiction and powers of all courts with respect to any of the aforesaid matters, but except with the consent of the ruler of the exceeding state, not so as to confer any jurisdiction or powers upon any courts other than courts ordinarily exercising in or in relation to the state. Right? So that's what
these subjects, do they correspond specifically to certain entries on the Government of India Act?
No,
probably they would have.
The subjects of the state were with reference to those residing in the state, those who had come to the state, those who were in Pakistan and came back. So that's a 1927 order, which I'll point to your lordship later. No.
Possibly the subjects which the instrument of accession
Yes,
recognizes in terms of the legislative powers of the Dominion
yes,
must cover certain specific entries in the Government of India Act. So
yes,
these subjects,
yes.
for instance, defense,
Yes,
1, 2,
we'll
3,
cover
4,
those entries, Madam.
there would be certain specific entries in the Government of India Act with reference to which there was an acceptance.
Correct, Madam. I will find that out and tell your lordship about which part of the Government of India Act covers these matters. I appreciate that. Then, Madam, kindly go back. Come back to volume 1, Madam. Yes. Then come to Madam's reply from Lord Mountbatten to Maharaja Harrison. That's at page 12.
Yes.
Page 12, Madam. My dear Maharaja Sahib, Your Highness's letter dated 26th October has been delivered to me by VP Menon. In the special circumstances mentioned by Your Highness, my government has decided to accept the accession of Kashmir state to the Dominion of India, consistently with their policy that in the case of any state where the issue of accession has been the subject of dispute, the question of accession should be decided in accordance with the wishes of the people of the state. It is my government's wish that as soon as law and order has been restored in Kashmir and a soil cleared of the invader, the question of the state's succession should be settled by reference to the people. Meanwhile, in response to Your Highness's appeal for military aid, action has been taken today to send troops of the Indian Army to Kashmir to help your own forces to defend your territory and to protect the lives, property, and honor of your people. My government and I note with satisfaction that Your Highness has decided to invite Sheikh Abdullah to form an interim government to work with you, with your Prime Minister. Then we go back to the list of names. PGA page 38, Mullah.
38.
38. And Mullah, I've already read to your lordships, Mullah, the acceptance, the letter of Mountbatten. So Mullah, we go to 23, 5th of March, 1948.
You want to go back to the list of dates and
Yes, Mullah. We'll go back to the list of dates, PDF 38, volume 1.
What page are you reading, Mr. Sim?
5th of March, Mullah, that entry. Because I've already read, Mullah, the 22nd of October letter of Lord Mountbatten. On the 5th of March, no, my lord has that. Volume 1, PDF page 38. Well, the 5th of March, 1948.
5th of March, 48.
Yeah, it's item 23. The ruler, your Lordship has that? The ruler Maharaja, I'm sorry.
1 minute, please.
Volume 2.
Volume 1, Madam.
It should-
Same
No,
list of dates that I was reading.
Some cases it's volume 2, some.
Written submissions, compilation, volume 2. That's correct. That's correct.
Written submission.
Yes, yes. WS volume 2.
Serial number 28.
PDF 38, WS volume 2. Yes. 5th of March 1948, the ruler Maharaja Hari Singh issued a proclamation under which a popular interim government was established in the state of Jammu and Kashmir, pending the framing of a constitution for the state. The proclamation inter alia. Well, it is better we read the whole proclamation. This is at volume 6, PDF page 242. Right. That's volume 6, PDF page 242.
Volume 6.
Forty-two. Says Millets, if your Lordship has it. My Lord Justice Surikant has it.
Volume 2?
242, Millets, volume 6, PDF page 242. Running page is 1291.
Good. Volume 6?
Volume 6.
The time. Yes, Maharaja on the 5th of March 1948. That's the one. I know this.
1291.
Running page 1291. That's correct. That's correct. Well, we have to show PDF, Millets, otherwise it becomes difficult. Okay.
Yes.
In accordance with the tradition. Well, it's all of them correspond to the provisions of the Government of India Act.
Yes.
They were more there, but they were whittled down. That's all. But they do correspond. Just wanted to answer your Lordship's on that. In accordance with the traditions of my dynasty, I have from time to time provided for increasing association of my people with the administration of the state, with the object of realizing the goal of full responsible government at as early a date as possible, and in pursuance of that object have, by the Jammu and Kashmir Constitution Act 1996, established a constitutional government with a council of ministers, a legislature with a majority, that's the Praja Sabha, with a majority of elected members, and an independent judiciary. I have noted with gratification and pride the progress so far made and the legitimate desire of my people for the immediate establishment of a fully democratic constitution based on adult franchise with a hereditary ruler from my dynasty as the constitutional head of an executive responsible to the legislature. I have already appointed the popular leader of my people, Sheikh Mohammed Abdullah, as the head of the emergency administration. It is now my desire to replace the emergency administration by a popular interim government and to provide for its powers, duties, and functions, pending the formation of a fully democratic constitution. I accordingly hereby ordain as follows. My council of ministers shall consist of the Prime Minister and such other ministers as may be appointed on the advice of the Prime Minister. By royal warrant, I appointed Sheikh Abdullah as the Prime Minister with effect from today. The Prime Minister and the other ministers shall function as a cabinet and act on the principle of joint responsibility. The Diwan appointed by me shall also be a member of the cabinet. I take this opportunity of giving once again a solemn assurance that all sections of my people will have opportunities of service, both civil and military, solely on the basis of their merit and irrespective of creed and community. My Council of Ministers shall take appropriate steps as soon as restoration of normal conditions has been completed to convene a National Assembly based upon adult franchise, suffrage, having due regard to the principle that the number of representatives from each voting area should, as far as practicable, be proportionate to the population of that area. In a way, he was adopting the principles adopted by us. The Constitution to be framed by the National Assembly shall provide adequate safeguards for the minorities and contain appropriate provisions guaranteeing the freedom of conscience, freedom of speech, and freedom of assembly. The National Assembly, as soon as the work of framing the new Constitution is completed, submit it through the Council of Ministers for my acceptance. In conclusion, I repeat and hope that the formation of a popular interim government and the inauguration in the near future of a fully democratic constitution will ensure the contentment, happiness, and moral and material advancement of the people. So go back to volume 2, written submissions compilation, volume 2, PDF page 38 again. So in 1949, item 24 was there. Volume 2, PDF page 38. Mullahs, in a football field when there is no play, Mullahs, that time has to be excluded.
There's always a play going around. And
I submit to that.
Who would better know about plays than you, Mr. Sibul?
I submit to that.
Time out, as we said.
Maharaja Hari Singh issued a proclamation delegating his powers and authority to Yuvraj Karan Singh, who would function as the ruler of the state. We don't have to go to that. Following his appointment as ruler, Karan Singh nominated 4 representatives from Jammu and Kashmir to the Constituent Assembly in India. But the Constituent Assembly actually was formed in 1951, right? This is our Constituent Assembly. Sorry. Now, December 1947 to September 49, princely states underwent a process of integration into the Indian Union by signing merger agreements or covenants of unionization. The state of Jammu and Kashmir was not a part of this process of integration. That's important. By the covenants of unionization, various princely states entered into covenants with each other to form single units. For example, through a covenant, the princely states of Bhavnagar, your Lordship need not read it because this is the Lordship's want. Junagadh, numerous others formed the United States of Saurashtra. Through a separate covenant, Gwalior, Indore, and 18 other princely states formed the Union State of Gwalior, Indore, and Malwa. Similar covenants led to the formation of Patiala, East Punjab States Union PEPSU, the United State of Rajasthan, and the United State of Travancore and Cochin. Between May 48 to September 49, the states of Saurashtra, Madhya Bharat, PEPSU, Matsya, Rajasthan, and Travancore and Cochin signed revised instruments of accession, which inter alia enlarged the powers of the Dominion legislature, permitting it to enact laws on all matters in lists 1 and 3, the Government of India Act 1935, and cancelled all previous instruments of accession entered into by rulers of princely states that had entered the covenants referred to above. Well, the Lordship may note that no revised instrument of accession was signed by the ruler of Jammu and Kashmir. Just note that fact for us. We're talking about December 47 to September 1949. Now, November 1949, through their respective rulers, Raj Pramukhs, the states of Saurashtra, Pepsu, Rajasthan, Madhya Bharat, Mysore, and Travancore and Cochin, amongst others, issued proclamations stating that the Constitution of India, shortly to be adopted by the Constituent Assembly, shall be the Constitution for the state, as for other parts of India, and shall be enforced as such in accordance with the tenor of its provisions. 25th of November 49, following the proclamations above, Rughurat Karan Singh issued a proclamation for the state of Jammu and Kashmir that the Constitution of India, shortly to be adopted by the Constituent Assembly of India, shall, insofar as applicable to the state of Jammu and Kashmir, govern the constitutional relationship between the state and the contemplated Union of India. We don't have to go through that document because it's all set out here. Then 26th of January 1950, in exercise of its constituent powers, the Constituent Assembly drafted the Constitution of India, which was adopted on November 26, 1949. The Constitution of India came into force on January 2650, repealing inter alia the Indian Independence Act, Government of India Act. The relationship between the Constitution and the state of Jammu and Kashmir was governed by Article 370 of the Constitution. It is evident that both the text of Article 370 and the negotiations that preceded its formulation, that Article 370 could not be changed unilaterally by Parliament. That's of great significance. Then, well, it's 26th of January 1950. Same day, in exercise of powers under Article 370, sub-Article 1 of the Constitution, the following consultation with the government of Jammu and Kashmir, the President issued. This is the first Constitution application to Jammu and Kashmir Order 1950. Under paragraph 2 of this order, matters in the first schedule to the order were declared to correspond to matters ceded to the Union of India through the instrument of accession, and subsequently the power of Parliament to make laws for Jammu and Kashmir was limited to such matters. Furthermore, paragraph 3 of the order declared that in addition to Articles 1 and 370 of the Constitution, provisions specified in the second schedule to the order would apply to the state of Jammu and Kashmir. It's important for us to go to this document, volume 3 of the documents, and it's PDF page 470. Sorry, page 4. Page 4, not 470. Page 4. Hold on. Oh, still finding it again. Yes. Yes, this is the first constitutional order. Yes. Well, and kindly note this is on the same day, on the Republic Day that you signed this, do this. That's of great significance. In exercise of the powers conferred by Clause 1 of Article 370 of the Constitution of India, the President, in consultation with the government of the state of Jammu and Kashmir, is pledged to make the following. This order is so and so, so and so. For the purposes of subclause B1 of Clause 1 of Article 370 of the Constitution, the matters specified in the first schedule to this order, being matters in the Union list, are hereby declared to correspond to matters specified in the instrument of accession governing the accession of the state of Jammu and Kashmir to the Union of India, as the matter with regard to which the Dominion legislature may make laws for the state, and accordingly the power of Parliament to make laws for the state shall be limited to the matters specified in the first schedule. In addition to the provisions of Article 1 and Article 370 of the Constitution, the only other provisions of the Constitution which shall apply in relation to the state of Jammu and Kashmir shall be those specified in the second schedule to the order, and shall so apply subject to the exceptions and modifications specified in the said schedule, and to the modification that all references in the said provisions to the Raj Pramukh shall be construed as references to the Sadr-e Riyasat of Jammu and Kashmir. So, if you look at this first schedule, you will find defense, what I had indicated earlier in the instrument of accession. You will find naval military, then you find delimitation, naval arms, atomic energy, preventive detention, foreign affairs, diplomatic relations, United Nations, participation in international conferences, war and peace, foreign jurisdictions, admission into and emigration and expulsion from India, passports, pilgrimages, railways, piracies, maritime, all that your lordships will find. That's part of the first schedule. And then in the second schedule,
about 96 items.
Sorry?
About 96 items.
Yes, 9. It's taken, yeah, they've taken the entries from the Constitution.
It's less than the.
Some are skipped, but they're not 96.
The number of the
From, see, 31 to 41 is missing.
72.
Yes, there are several that are missing.
It's only the same Sheraton number.
That's correct. That's all that there is.
At least one. This one.
Correspond to the instrument of accession, actually,
Yes.
The defense, military.
No, that may not be correct, Mr. Sebu. The instrument of accession, the schedule which is short, was far more restrictive. These are, you can say these are more elaborate.
No,
but
they
these do
relate
not
to the
correspond.
Constitution. I'm sorry.
They do not correspond. They're not.
No, correspond in the sense that they relate to defense. That I'm not saying anything more than that. They relate to defense, they relate to external affairs. That's all that I'm saying, because the entries in the union list.
You read out the second schedule earlier at page 2, if I'm not mistaken, 196.
Correct. I'm not disputing that.
176.
When I said correspondent, I said the broad heads. That's all that I meant. Then say this schedule 2, is important. Article 72(1)(c), 72(3), 133, 134, 135.
Just one more clarification. This is by an order.
Yes.
This is by an administrative order.
Yeah. Under Article 370.
370.
Yes, that's all. That's what I told your lordship in the initial stage. Constitution of India as applicable to the state of Jammu and Kashmir.
Correct.
That's all I meant. That's right. That's correct. Numbers, kindly see these exceptions are at 72(1)(c), 72(3), 133, 134, 135, 136, 138, 145, 151. Articles 80 and 81 shall apply subject to the modification that the representatives of the state in the Council of States and the House of the People respectively shall be chosen by the President in consultation with the government of the state. So that was the variation. Articles 54, 55 shall apply subject to the modifications that references therein to the elected members of both houses of parliament and to each elected member of either house of parliament shall be deemed to include, respectively, a reference to the representatives of the state in those houses and to each such representative. That the references to the elected members of the legislative assemblies of the state and to each such elected members shall be deemed to include respectively a reference to the members of the constituent assembly of the state and to each such member, and that the population of the state shall be deemed to be 44 lakhs and 10,000. But at the moment, it's about 14 million. 140 million, that's 14 crores. Now, Articles 149, 150 shall apply, subject to the modification that the references therein the state shall be construed as not including state of Jammu and Kashmir. Then, Article 246 shall apply, subject to the provisions of paragraph 2 of this order, and clause 2 and 3 of Article 246 shall not apply in relation to the state. So, no issue of repugnancy or anything like that. They can't pass laws because the residuary power of the state. Then 259 shall apply subject to the modifications that after the words until Parliament by law otherwise provides, the words and the concurrence of the state to such law has been obtained shall be deemed to be inserted. Article 266 shall apply only insofar as it relates to the Consolidated Fund of India and the Public Account of India. Article 282, 284 shall apply only insofar as they relate to the Union or the Public Account of India. 298, 299, 300 shall apply insofar as they relate to the Union. And 324 shall apply only insofar as it relates to elections to Parliament and to the office of the Vice President. So it doesn't apply to the elections in the state. 324, then 335, and then provisions of this part. 361 shall apply only as far as it relates to President. 364, 368 shall apply, provided further that no such amendment shall effect in relation to Jammu and Kashmir unless applied by order of the President under clause 1 of 370. So, Malas, the point that I'm making here is very simple, that the government of the day accepted the fact that our relationships with the Jammu and Kashmir government are on a separate footing. The provisions of the Constitution, unless made applicable through a presidential order and agreed to by the government, shall not apply. The residuary power will vest in the state. It is the state which must pass laws. The government of India can't, under the issue of repugnancy doesn't apply. So, well, this status is accepted. That's how 370 came into being. And it continued. Yes, so that will come to later. Then the distribution of revenues, well, it comes, and that we are not really concerned with at the moment. Now kindly come back to volume 2, Madad, of the written submissions, volume 2, page 41. That's what we have shown. Page 41.
The Constitution.
So the assumption is that if the President passes a notification for the application of any law to the state of Jammu and Kashmir, he has to seek concurrence. He cannot do it without concurrence. Consultation. Yeah. So it was a collaborative relationship in a sense. There was a constant dialogue going on. This is what we wish to do, and let's consult the state agrees, which is why most of the laws were made applicable. There was hardly any law that was left. So in a sense, they were incorporated separately in the Constitution of India in its application to the state of Jammu and Kashmir orders.
What happened to currency, for instance?
Currency, Malaj, was the Sarveri Riyasat, as your lordship knows, Malaj. Currency. No, currency was Indian currency.
No, because, if you see currency in the Constitution is governed by entry 36 of List 1.
Yes.
But there's no reference to entry 36 of List 1 in the adaptation order.
But it will come later, Malaj. There were adaptation orders, subsequent adaptation orders. I'll come to that. I'll show that, your lordship. Because several, this comes in 1954, we have another adaptation order. There are several, give me on the list of several adaptations. We got on the list by your lordship.
So were the subjects broadened by the subsequent adaptation orders?
Of course, Malas. Of course. They were broadened, Malas. Every stage they were broadened. We have an order of 52, we have an order of 54, we have an order of 71, an order of 74. Because the powers were extended, Malas, and the state, Malas, after consultation it was done. The state was ad idem with the union, Malas. I mean, the state itself in its constitution says that we are integrated into India. There was no question. The constitution of Jammu and Kashmir itself says that we are an integral part of India. So where's the question? The only thing is that there's a unique structural system in place, a constitutional structure which was in place, which suddenly, Malas, on the 6th of August was done away with. And Malas, with the greatest respect, though I don't want to use that expression, suddenly, Malas, in Parliament, it was said that we are doing this at 11 o'clock. Nobody knew about it. There was no consultation of any sort. So it was, Malas, as I said, the governor of the state and Parliament, and of course the powers that be, they decided to do this one fine morning and tossed it out. So, Malas, page 41. The Government of India published its white paper on Indian states clarifying the nature of Article 370. The effect of this provision, this is important, we're talking about 1950 itself. The effect of this provision is that the state of Jammu and Kashmir continues to be a part of India. Nobody disputes it. Nobody ever disputed it. It is a unit of the Indian Union. And the Union Parliament will have jurisdiction to make laws for the state on matters specified either in the instrument of accession or by later additions with the concurrence of the government of the state. My lords asked me that question. Steps will be taken for the purpose of convening a constituent assembly. The lordship knows, Malas, this is very important. At that time, when, Malas, we became a republic, 370 was there. And 370 mentions the Constituent Assembly. But the Constituent Assembly had not yet been convened in the state of Jammu and Kashmir. That was convened in 1951, December. Point is that there was this understanding between the Government of India and the state that we will have a Constituent Assembly which will determine the future course of action. Determine whether or not, Malas, in fact, 370 should be abrogated at all or not. That decision was with the Constituent Assembly. Which is why it is called a temporary provision. Not for any other reason. It's in that chapter of the Constitution. So this whole argument that this temporary provision was 370 was temporary, no. It was temporary because between 1951...
Mr. Sable, what is the date of this white paper?
50. I'll give you...
No, you're not given the date.
I'm sorry. It's at page 121. Just see the date. We'll just give it to you in a minute. I'll give it to your lordship. Just. So on the 1st of May 1951 now, Yuvraj Karan Singh issued a proclamation directing the establishment of an elected Constituent Assembly. March 1950, I'll give the exact date.
Okay.
It is March 1950s. Huh? Can't be.
It cannot be 5th July 48.
It can't be. We'll give the date, Malas. I thought it was March.
Article 370 wouldn't have been then.
But in any case, Malas, the idea is that it's prior to 1951. That's the whole point. whatever the date is, it's prior to 1951. In other words, the Constitution envisaged a constituent assembly which was to decide as to what would be the fate of Jammu and Kashmir. 15th March 1950 is what I'm told. Huh?
15th March.
Anyway, let's not get into this. We give it. Why amongst ourselves in the day? It's prior to 1950.
Well, you can verify it and then give a date.
I'll give it. Yeah, give it to your lordships. 1-5. Sorry. $254 now. They didn't correspond, the 1950, the order didn't correspond, but as if you look at the 50 order, it says para 2, for the purposes of subclause B1 and clause 1 of 370, matters specified in the first schedule to this order, being matters in the union list, are hereby declared to correspond to matters specified in the instrument of accession. Just wanted to mention that. Para 2 itself says. So, my lords, we all have done. On the 1st of May 1951, Karan Singh issued a proclamation directing establishment of an elected constituent assembly to draft a constitution for the state of Jammu and Kashmir. Then 20th of March 1952, under Article 370, Sub-Article 1 of the Constitution, and following consultation with the government of Jammu and Kashmir, the President issued the Constitution.
Just one.
I'm going to better read it now. $374. That also is the same thing. The same article. 370 for a minute, but they'll give your lordship some.
No, just continue. Where you want, whichever way you want.
No, but let's read 370 because the context will be clear. That's how it was understood at that point in time. We're talking about January 26, 1950. Yeah. Well, let's, my lords, have the Constitution.
Yes.
It says, my lords, notwithstanding anything in this Constitution, the provisions of Article 238 shall not apply in relation to the state of Jammu and Kashmir. Now, 238 is Part A, Part B, Part C, Part D states. That's what 238 was, so it couldn't apply. It's neither, the Jammu and Kashmir didn't fall into that category. Sui generis. The power of Parliament to make laws for the said state shall be limited to those matters in the union list and the concurrent list, which in consultation with the government of the state are declared by the President to correspond to matters specified in the instrument of accession, governing the accession of the state to the Dominion of India, as the matters with respect to which the Dominion legislature may make laws for that state. And such other matters in the set lists as with the concurrence of the government of the state, the President may by order specify. So the items, whether it's communication, defense, foreign affairs in consultation, for all matters concurrence, for all other matters concurrence. Explanation. For the purposes of this article, the government of the state means the person for the time being recognized by the President as the Maharaja of Jammu and Kashmir, being acted on the advice of the Council of Ministers for the time being in office under the Maharaja's proclamation, dated 5th day of March 1948. This explanation was added later, Maharaj, and I'll point that out to your Lordship later. It was amended later, Maharaj, this particular explanation. The provisions of Article 1 of this article shall apply in relation to that state. Such of the other provisions of this Constitution shall apply in relation to the state, subject to such exceptions and modifications as the President may by order specify, provided that no such order which relates to matters specified in the instrument of accession of the state referred to in paragraph 1 of subclause B shall be issued except in consultation with the government of the state, provided further that no such order which relates to matters other than those referred to in the last proceeding proviso shall be issued except with the concurrence of that government. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in second proviso to subclause D of that clause be given before the Constituent Assembly for the purposes of framing the Constitution of the state is convened, it shall be placed before such assembly for just decision as may be taken thereon. Notwithstanding anything in the foregoing provisions of this article, the President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify, provided that the recommendations of the Legislative Assembly of the state shall be necessary before the President issues a notification. Constituent Assembly. This now is replaced by the Legislative Assembly. The Constituent Assembly. So you had to have a recommendation of the Constituent Assembly before you could efface 370. That's what the Constitution makers themselves thought in 1950. And that operated till 6th of August. How could it change?
But how long would the tenure of the Constituent Assembly of the state be?
7 years.
Sorry?
6 years, 51 to 57.
So therefore, with the end of the 7 years, the very institution of the Constituent Assembly of the state lapses, then there's no Constituent Assembly left.
Absolutely.
But then what happens with the proviso?
But
then what happens with the proviso then?
This is exactly the point, Maharaj. This is exactly the point. Maharaj, the in between 51 and 57, the Constituent Assembly could take that decision.
But thereafter,
Maharaj, there's no question because they formed the. Maharaj, take the Constitution.
What happens after the Constituent Assembly has come to an end? Because no Constituent Assembly can have an indefinite life.
That's precisely the point, Maharaj. That is my point. The Constituent Assembly in India, when it drafted the Constitution, can't have a life after the Constitution is framed.
No, but equally, The proviso to clause 3 refers to the recommendation of the Constituent Assembly of the state.
Yes.
The substantive provision says that the President may by a notification declare that the article shall cease to be operative.
Yes.
Right? Now, the only safeguard is that before the President does so, the recommendation of the Constituent Assembly of the state has to be taken.
Yes.
Now, what happens at a point of time where the Constituent Assembly of the state ceases to exist?
But that's the point. The President can't issue such a notification.
According to you, after 57, it can't be done at all.
No, after 57, it can't.
Then clause 3,
That's what
exactly.
that's
What
why
happens to the temporary used in the
that is
article?
why the temporary provision.
No, but that's just
because
because
Manoj, this
one more fundamental issue, which is that notwithstanding the fact that the proviso ceases to operate, clause 3, the substantive part, continues to hold the field.
No, it is dependent on the proviso.
No.
With respect, no, Manoj. With respect, any proviso.
If the
Manoj,
proviso, I mean, there are ways in which you can construe a proviso, but if the proviso ceases to operate by virtue of the fact that the tenure of the Constituent Assembly of the state has ceased to exist, surely the substantive part of 3 still continues to remain.
Kindly see the scheme of 370, Manoj, with the greatest respect. Kindly see the scheme of 370. On the 4 items, Manoj, that is defense, communications, external affairs and ancillary matters, Manoj, the consultation of the state is necessary under 370. For all other matters, the concurrence of the state is necessary. So can you say you do away with the concurrence? And then the third thing is, if you want to abrogate 370, then or amend it, you have to get the recommendation of the Constituent Assembly.
So
what
long
is
as it
put
exists.
to me,
So long as it exists.
Manoj, I'm sorry, Manoj, this is the point, Manoj. That's why I said initially, the Constituent Assembly, Manoj, has served its term when a constitution is framed.
So in which case, then what happens is if your construction is right, 370, which is essentially a transitional provision, assumes the character of a permanent position.
No, it is a transition.
By virtue of the fact that there is no Constituent Assembly of the state after 1957.
Absolutely. It's a transitional provision between 1951 and 1957 when the Constituent Assembly could take that decision. Which was left to the people of Kashmir.
So according to you, after 57, sub-article 3 has become redundant.
Whereas Constituent Assembly, even in the context of Constitution of India, is redundant.
So there is
You can't revive a Constituent Assembly.
There is no method, according to you,
Yes.
by which either with consultation assembly or
Yes,
otherwise,
yes.
can 370 at all be abrogated?
Malaj, the amendment that is made ultimately, they convert the legislature into a Constituent
That's a
Assembly.
different matter.
No, but that tells you their understanding. Please appreciate that. It's their understanding of the Constitution.
No, Mr. Sibyl, there are 2 separate aspects. One is interpretation of clause 3 of Article 370 and the proviso to that.
Yes,
The second part is what the amendments have been made and how do you interpret.
yes. Well, I can't hear your lordship. Yes.
One is interpretation of clause 3 to
Right,
Article
right.
370 has to be done independently of the amendments.
Right.
So your contention is the proviso specifically applies, and unless the proviso is resorted to, and it cannot be resorted to after 1957, clause 3 will not be applicable. That's your sum and substance.
Yes, absolutely. That's absolutely right, Malaj. That's absolutely right. Whereas, just as clause 2(3) has worked itself out. Malaj, the point is, why was this clause put in 1950? Because in 1950, they said we'll have a Constituent Assembly. See the Constituent Assembly debates, it will be made clear.
51 to 50 is there.
No, but the fact is in 370, at that time the Constituent Assembly was not there. The whole purpose was. Yeah.
To accept your submission, we'll have to postulate that clause 3 becomes a sort of a constitutional article which falls into desuetude after 7 years.
Yes, absolutely. Because
How can that be?
Whether
Clause 3 still continues to survive.
whether
The limitation
Kindly
on
see
clause 3 may cease to operate.
kindly see 369. Continues, mothers. Kindly see 369. Temporary powers to Parliament to make laws. That's the part. Part 21, mothers.
See, 371 begins with a non-obstante clause. It
Yeah.
overrides the entirety of the Constitution.
Absolutely. Mother.
But
So does
clause
the
3 contains a non-obstante clause which overrides clause 1 as well.
Yes.
So therefore, notwithstanding, because 371 makes special provisions in relation to the state of Jammu and Kashmir.
Correct.
But 373 has a non-obstante provision which overrides the non-obstante clause in clause 1.
For that period, Manoj, we are not disputing that. What your lordships is putting to me, there is a structure in place that was envisaged by the Constitution in Manoj 1950. At that time, there was no Constituent Assembly. Why did they mention Constituent Assembly? Need not have mentioned it. Kindly look at it from that point of view. What was the reason to mention Constituent Assembly in 370 when it was not even in place? They could have said Government of Jammu and Kashmir. Why did the Constitution makers, Manoj, include the term Constituent Assembly in 3? Because they knew that the Constituent Assembly will frame a constitution.
There was no limited, the acceptance of sovereignty of the Dominion of India was complete. They didn't say in the instrument of accession that we accept the sovereignty of the Union of India for some limited purposes. They accepted the sovereignty for all intents and purposes. That acceptance of sovereignty was complete, but they reserved certain rights to themselves over certain legislative subjects. So in that sense, the accession was complete. The acceptance of sovereignty was complete. Now, consistent with that, therefore, it said that in clause 3, that the Union of India would have, the President of India would have the right to abrogate Article 370. It conditioned that subject to
not the Union of India, but that's on the recommendation of the Constituent Assembly. Not Union of India has no right to till that it is recommended. The word is recommendation of the Constituent Assembly. Then they can exercise that right. That's how you interpret a proviso. You can't say that they have the right sovereign, forget the proviso, even the recommendation of the Constituent Assembly, because it doesn't exist. Then 368 2 proviso also goes, Maras. Therefore, the reason is simple, Maras. The genesis of it was the fact that in 370 itself, it was mentioned that the Constituent Assembly has a role to play in the abrogation of 370. Otherwise, if your lordship says it had no role to play, there was no need for 370 sub-article 3. And look at the concurrence power. Even those powers were of no relevance thereafter because the Constitution of Jammu and Kashmir was in place. Therefore, there was no need for concurrence anymore. Because now you have a Constitution of the Jammu and Kashmir. So that also became ocious. You have to see, Malad, the historical perspective in the context of which Jammu and Kashmir ultimately signed the instrument of accession. Nobody disputes whether they are integrated into India, but subjected to a constitutional provision.
Therefore, the submission is that once the period stipulated in the proviso to clause 3 had come to an end,
yes,
the power under clause 3 itself came to an end.
Because it's no longer alive. The Constituent Assembly, like in India, Malas, can, for example, today, Malas, there can't be a provision in the Constitution of India with reference to a Constituent Assembly, because the Constituent Assembly has worked itself out. It has formed the Constitution. Now, if it is decided that they would abrogate 370, the Constituent Assembly would have said, we abrogate 370. Which is why it was a temporary provision. Not because of the fact that under as a Union of India, it was
Oh, Mr.
Deemed to be a temporary. How could it be?
Simple, sorry, interrupting you at this stage. It does maybe just putting a question.
Sure,
I'm
sure.
not. If one looks at Article 370, clause 1B,
1B, yes.
the power of the Parliament to make laws for the state shall be limited to, it says, matter in the union list and the concurrent list in consultation with the, which in consultation with the government of the states are declared by the president to correspond to matters specified in the instrument of accession governing the accession of the state to the Dominion of India.
Right.
To such other matters in the list as with the concurrence of the state, government of the state, the president may, in the order may specify.
Yes.
Then explanation deals with the, what is meant by the concurrence of the state.
Right.
Then it says that provided that no such order, the first proviso, provided that no such order which relates to the matter specified in the instrument of accession of the state referred to in paragraph 1 of subclause B shall be issued except in consultation with the government of the state.
Correct.
Provided further that no such order which relates to matters other than those specified in the last preceding proviso shall be issued except with the concurrence of the government.
That's right.
So the second proviso talks about concurrence of the government.
Yes.
Now, if one looks at clause 2,
Yes.
it deals with a situation where the assembly or the government of the state is not there. It deals with the period when the constitutional assembly of the state was in existence, but the government or the elected assembly was not in existence. And therefore, the proviso to clause 3 will only be applicable as long as the government of the state or the assembly is not elected. Because election of the assembly will take place after the constitutional assembly of the constitutional assembly of the state of Jammu and Kashmir enacts the constitution.
Government was always in place from day one.
No, maybe so.
Government is always
Because
in place from day one.
that appears to be the broad outline of this, outline of Article 370. What clause 2, when it refers to the constitutional assembly of the state, it is for the purpose of for framing the constitution of the state, which shall be placed before the assembly for such decision as may be taken thereon.
Correct.
So the constitutional assembly of the state makes the constitution, frames the constitution, it goes before the constitution.
No, it can state in the constitution that that the 370 is abrogated. What problems are there? It has the power. That's why there is a constituent assembly. And it says, Malaj, notwithstanding anything in the foregoing provisions, kindly note that. Notwithstanding, Malaj, 37.1B1 and 37.2, notwithstanding any of that. So, Malaj, you start the article by saying notwithstanding anything in this constitution, and 3 starts with notwithstanding anything in the foregoing provisions. That is notwithstanding the opening part of the article also. There was a government, yes. Yes.
Extent of Constituent Assembly of the state.
Yes.
If sub-article 3,
Yes.
according to you,
Yes.
has become non-existent, ceased to operative,
Yes.
then how the very temporary nature of Article 370 will survive?
That's why, because it's temporary, because the Constituent Assembly had not been framed, but at that point in time had not been constituted. In 1950, when this provision was added in the Constitution.
No, if sub-article 3 goes, then that means Article 370 can never be abrogated.
Yes, that's the whole point, Mullah. That is our case.
Then how it is temporary?
It is temporary because when this article was framed, Mullah, there was no Constituent Assembly. It was the Constituent Assembly which could have taken the decision that we will abrogate 370 and merge completely with the Union of India like any other state.
Mr. Sibal, your contention, if I've understood you correctly, is that the temporary nature of 370 is correlatable to the
Life of the
Assembly.
Constituent Assembly.
Life.
That's my
And
argument.
in a way, subclause 3 becomes otious once the Constituent Assembly ceases to exist.
Correct.
This is your contention.
My contention.
From 51 to 57, it is temporary.
Your lordships of the Constituent Assembly, they say the same thing. Mr. Iyengar, they say the same thing, what I'm saying, Madam.
I'm just trying to phrase it as I understand it. I'm clear that
your lordships have understood it, and I also understand your lordships, what your lordships are thinking, Madam. So I have to respond to that.
According to it is temporary between 51 to 57.
That's correct.
And thereafter permanent.
The reason is simple, Madam. All constituent assemblies are temporary. There is no permanence in a constituent assembly. So when you
role is limited to framing the constitution.
Yes. Therefore, Malad, if it is temporary by its nature, which is why I started by saying this is a political exercise. That's why I, Malad, started with that summation before your lordships. The formation of a constituent assembly is a political exercise to ensure that people within the territory of a particular region, their aspirations are taken into account to formulate a law and a constitution to ensure that those aspirations are met in future times to come. It's not a law-making exercise. Then they framed the constitution to take into account those aspirations. That's how our republic came into force. Because there was the 1935 Act, there was diversity. But let's kindly look at it historically. Let's not forget the law for the moment. Look at it historically. If you look at Europe, and the making of the nation states in Europe, how did that happen? It happened because there were large empires, the Austro-Hungarian Empire, Prussian Empire. And whereas those large empires had communities and within those empires, there were peoples of different languages, of different cultures, of different ethnic lot. So it is the breakup of the empire that led to the rise of the nation state, the Treaty of Utrecht, the 1848 revolutions, right? In India, the process was the opposite. It's the only exception. The process was just the opposite. There was disparity. There were existing disparities. There were 562 princely states. There were states, which were part of the British Crown. They had to be amalgamated. And each of them, had certain conditions. But then ultimately they all agreed, okay, for the states that were part of 562, all agreed. But this particular state of Jammu and Kashmir was an exception. And the exception was constitutionally engrafted in Article 370. And the terms of the exception were constitutionally engrafted in 370. You can't jettison the people of the state of Jammu and Kashmir and decide that then what's the difference between this and the act of the crown? What's the difference between this and the annexation of Junagadh? Or the annexation of Hyderabad? Then it's an act of paramountcy that I am the union and I will decide. When you have constitutionally committed yourself that if this is to be done, you have to follow a process which two sovereign authorities have agreed upon and engrafted in Article 370. Otherwise, then it's exercise of paramount power.
In the assimilative exercise carried out, your submission, as I understand, is J&K is an exception because a temporary provision was created for a period of time, and after that it is engrafted permanently into the Constitution.
Because you can't revive the Constituent Assembly.
I'm just saying, what is that?
That's what my submission. I appreciate, your lordships have fully understood what I'm trying to say. What is it that you have a state of Jammu and Kashmir with today 14 million people. At that time, they were much less. They have no role to play in their own fate. They have no role to play. If in 1950 it was part of the union, there would be no issue. The aspirations, the desires of the people, whatever it is, Malad. After all, this was something that also had international repercussions at that point in time.
If a elected assembly would want to abrogate 370, even that is not possible.
Not possible. Not possible. That is why they had to do these things in the manner that they did.
But the only way we can reach to that conclusion is by saying that once the period for the work of the Constituent Assembly of the state comes to an end, then what is essentially a temporary provision assumes a permanent character in the Constitution.
But that, yes, Lordship is right. Except,
but if that hypothesis is not accepted, then the only basis on which you can really, place your petitions here is that by asserting that a pre-constitution compact, which was entered into between an independent state and a state in which it has merged, so to speak, is enforceable, irrespective of what the legislative power of the merging state is.
because the legislative power, both of the parliament here, cannot override the powers under 356 of the Constitution. Because what has been used is 356. There is no such power under 356 that can take
Or can an independent state, which accepts the sovereignty of another state unconditionally, still say that, well, if the parliament of that state to which we have assumed the sovereignty of is still restrained in terms of the original compact?
It's unconditional, it's unconditional. And apart from, forget about that. Can Parliament of India, Parliament of India, in the context of its responsibilities and powers under the Constitution of India, do an act beyond 356? Can't. There are very complex issues that your lordships will have to decide. This power is exercised under 356. How is that can be exercised under 356? 356 itself is a temporary power. What are you trying to say to me?
Well, what you are saying, you see, which means even, let us say, a hypothesis that the will of the people is to abrogate it.
Yes.
Which is reflected by an assembly elected.
Yes.
You are saying even that scenario, it cannot be done. Trying to understand the consecutor would be, even then it can't be done.
But that would be a political act then, I would say that if that situation arises, it would be a political act. That's not been done, but be that as it may. Well, kindly look at it from this point of view. 356 itself is a temporary provision. What's the purpose of 366? To restore democracy. Is the intention behind the 356 position, which is a temporary provision, to decimate democracy?
No, it's simple. Let's keep 356 aside for the time being, because we are now interpreting 370. We are interpreting clause 3.
Yeah. I'm just
70.
Yeah, I appreciate
we can't bring.
No. I'm only saying these are issues that will arise.
If one looks at it carefully,
Yeah.
subclause B2 says such are the matters in the said list with the concurrence of the government of the state, the president may by order specify. So all other matters which are not included in clause 1 can be now the parliament of the country can legislate with the concurrence of the government of the state.
Correct.
Now, what is meant by the concurrence of the government of the state is specified in clause 2.
Yes.
As long as there is no legislative assembly.
Correct.
In that case, it's the Constituent Assembly which will have the power.
Yes.
And after the State Assembly has been constituted, then it will be placed before the State Assembly.
Correct.
That's the purport of clause 2.
Absolutely right. So that's also worked itself out.
One.
Yes.
But once the State Assembly has been constituted,
Right.
in terms of the Constitution of the state, then it is governed by the proviso first and the second proviso to clause 1.
Yes.
Which says, provided that no such order which relates to matters specified so and so in consultation with the government of the state, concurrence is not required because it's already included in the
Yes.
order of accession. The second proviso applies when it is not included in the order of succession and says, provided further that no such order which relates to matters referred to in the last provision shall be except with the concurrence of the government.
Correct.
So all that is required is concurrence of the government.
Right.
But to say that the proviso to clause 3
Right.
will operate even after
No, it
the
says this
constitution.
article shall cease to operate, not just any laws, that this article shall cease to operate. There's a difference, Malad. Actually, proviso 1 and proviso 2 have worked themselves out. Because now you have a constitution.
Yes, it's not worked itself out. It will continue to apply as long as there is concurrence of the state government.
That's right. And in between, the constitution in 1957 is framed, Malad. So that there was no CO after that. Except for the ones, there were a couple of COs, but ultimately it's in three, it's in that's different. No. See, it says notwithstanding anything in the foregoing provision of this article. This article.
Well, we are interpreting 370. Let's look at it. Let's look at clause B, C, and D for a moment.
Yeah.
B, C, and D cover two types of situations.
That's
one. It covers entries of the union list and the concurrent list.
Yes.
And it covers substantive provisions of the Constitution also. Now, clause B refers to the power of Parliament to make laws for the state.
Yes.
And it restricts it in two ways.
Yeah.
First, those matters which are governed by the instrument of accession, those entries in the union list and in the concurrent list, which are referable to the instrument of accession insofar as it reserves powers to Parliament.
Right.
Those have to be specified by the Government of India, by the President,
absolutely,
in consultation with the state.
Absolutely.
So B1 refers to those matters in the union list and the concurrent list.
Right. Right.
B2 refers to such other matters in the said lists, yes, in which concurrence of the government of the state is concerned. Right? So the entirety of B is confined to matters in the union list and the concurrent list.
Correct. Correct.
Now we come to clause C.
Yes.
Clause C refers to a substantive article of the Constitution,
right,
Article 1.
Yes.
Right? Now we come to clause D.
And 370, not just Article 1.
Right. And of this article, you're right.
And this article.
And now clause D. Clause D refers to such of the other provisions of this Constitution.
Right.
They shall apply in relation to that state subject to such exceptions and modifications as the President may by order specify.
Correct.
So clause D now is beyond the ambit of clause A. Clause A refers only to the entries of the union list and the concurrent list. Right? Clause D refers to the other provisions of the Constitution, apart from the union and the concurrent list.
1 and 370. This is the problem.
Right. Now look at the proviso to clause D.
Yes.
The proviso says that no such order which relates to the matters specified in the instrument of accession of the state referred to in paragraph 1 of subclause B,
correct,
shall be issued except in consultation with the government of the state.
That's right.
In other words, the first proviso,
yes,
refers to the entries of the union list and the concurrent list.
Yes.
Right?
Right.
The second proviso provided further that no such order.
Yeah.
Now, which is such order? It refers to the order which is referred to in the first proviso. Therefore, the use of the word such order, which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of that government. In other words, the whole area of concurrence, consultation and consent is confined to the entries of the union list and the concurrent list. Because that's very clear from the whole scheme. B1, matters in the union list and the concurrent list. B2, such other matters in the union and the concurrent list.
Yes.
Then go to clause D.
Yes.
Clause D refers to the provisions of the Constitution,
Provisions of this constitution.
of this Constitution.
Yes.
Right?
Yes.
Now,
Subject to, it will be
the
applied-
presidential power, the presidential power to, the power of Parliament or such of the provisions of this Constitution shall apply in relation to the state subject to such exceptions and modifications as the President may by order specify.
Yeah.
In other words, the President is given an untrammeled power to specify which are the provisions of the Constitution which shall apply to the state of Jammu and Kashmir. That is conditioned by the first proviso and the second proviso.
Right.
But the first proviso and the second proviso don't relate to the substantive provisions of the Constitution at all. They only refer to the matters governed in the union list and the concurrent list.
Only the first proviso, not
One second.
Orders, Mother.
Right. You're right.
Yes.
D deals with deals with the presidential order.
First proviso mentions
But-
the list,
but
Mother, not the second
D,
proviso.
D recognizes as inhering in the President the power to decide which of the substantive provisions of the Constitution shall apply to Jammu and Kashmir. Now, that power of the President
That's
is conditioned by the first and the second proviso.
Yes.
But the first and second proviso to clause D
No, see,
only.
provided further that no such order shall relate.
So no such order means the order referred to in the first proviso. And the first proviso only refers to clause 1
Whereas
of
these only
subclause
orders,
D.
Mother, not these only orders. Yes, these orders.
I
Mother.
understand that, yes. No, 1 second. No, you're not getting the point. The point is this, that D refers to an order which may be passed by the President, making applicable provisions of the Constitution to the state of Jammu and Kashmir with adaptations or modifications. Now the question, including the list, now, yes, now what the first proviso says is that no such order which relates to matters specified in the instrument of accession specified in paragraph 1 of clause B shall be issued except with
That's the
consultation.
instrument of accession, Mother.
But that pertains only to the entries in the union list and the concurrent list.
Yes.
Absolutely.
Yes,
You read
Mr.
the face of it.
That's,
The second proviso, Mother.
Now the second proviso. Now the second proviso says, provided
Other than
that
those
no such order
Yes.
which relates to matters other than those referred to in the last preceding proviso.
Concurrence.
Therefore,
Which includes D, Mother.
no, it refers only, it cannot. I'll tell you why. Provided further that no such order means which order? The order referred to in the first proviso. And the
He
order
also
referred,
mentions order, Mother.
sorry?
He also mentions order.
provisos, use the word such order,
Such order.
refers to the order in D. Just 1 minute.
But it is not. D also says the same thing. May order specify.
Silence.
And also by an order. By an order.
That's right. There is different methodology, but Parliament won't take the
Lords, Honorable the Chief Justice, in the morning I'd mentioned a matter. There's higher urgency. There are 23 protests going on simultaneously with, well, we have a very volatile situation due to very unfortunate situations that happened in the neighboring state in Haryana and Nu. Now there are 23 protests going on in Delhi.
You've circulated your, have you circulated your email?
We sent it to the.
I'll pass orders immediately.
If your lordships could please, at
of course, that's what the circular says. I'll do that.
Can I hand over hard copies of the IA, Lord?
You circulated an email, right? I'll pass orders.
But the email went to the learned registrar judicial because we couldn't find another email.
He doesn't even allow me to use the washroom. He's waiting just outside to take orders the moment I come to my chamber.
Right. Well, we also circulated to the Honorable Court Master, your lordship's court.
Yes. Whether Khanna's reading is that it will include D, but C, but exclude A and B.
Cannot.
It will. Otherwise, it will lead to a situation you are saying that 370 is a permanent article.
But we'll come to that later whether it's
1 minute, yes, that's your argument. 370 is a permanent article which cannot be undone by even with the concurrence.
Let me forget that when I made that argument.
Right now, you're just giving us the structure of the article.
Forget that what I made that argument.
That you're giving us the structure. Yes.
It is temporary on 26th of January 1950. Let's forget about anything else. It is temporary. Why? Because, Malats, the Constituent Assembly may still choose to. So it's temporary. There's nothing wrong with that heading. Let me finish. Let me finish the architecture and then I'll come back. So, Malas, I was reading such of the other provisions of the Constitution. So that is other than 1 and 370, shall and 238, shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. Now you come to orders, not to laws. Provided that no such order, what order? Order under D. Colon, read the colon, Mother, specify colon. Right? Provided that no such order which relates to the matter specified in the instrument of accession, again, mothers, of the state referred to in paragraph 1 of subclause B shall be issued except in consultation with the government of that state. Again, a colon. Provided further that no such order which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence. You go to B1 and B2. So that was the law, the same template, now the orders for the rest of the provisions. Then read 2, Malats. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in second proviso to subclause D of that clause be given before the Constituent Assembly for the purpose of framing the constitution of the state is convened, it shall be placed before such assembly for such decision and may be taken thereon. Same template of B and D, Malak. And they can reject it. They need not confirm it. That's how you retain sovereignty, which is the instrument of accession. And if it don't retain it, it's temporary. That's why temporary. Well, I'm just trying to explain with
the structure of 370. Yeah. You complete clause 3. Yeah. Then I have one question.
Sure,
but but we'll first, you can complete, otherwise I'll be breaking your link. It's on some unrelated area, therefore.
Notwithstanding anything in the foregoing provision. So, Malad, it's notwithstanding the notwithstanding in the beginning of the article. Please note that. Notwithstanding anything in the foregoing provisions of this article, so notwithstanding the notwithstanding in 370, the President may by public notification declare that the article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify, provided that the recommendation of the Constituent Assembly shall be necessary before the President issues such a notification. So if the Constituent Assembly recommends it, namely, that we want to abrogate 370, then on that recommendation, the President will issue a notification. And this article is contained in subclause 3. Doesn't have to be in D. So that, according to me, is the architecture of 370.
Now, Sibyl, I have just one question on this. B1 refers to those matters in the instrument of accession which have been ceded by the Maharaja to the Union, the Dominion's power. B2 refers to all other matters in the Union and concurrent list other than what is covered by 1.
Fair enough.
Now, suppose in the area of the Union and the concurrent list, something is not covered by B1 or by B2. In other words, it's not referable to those subjects mentioned in the instrument of accession, and it's not covered by B2 at all. That power is not entrusted to the state.
B2 is all other lists, Mullah.
No. B2 says such other matters in the said list as with the concurrence of the government, the president may order specific.
So all matters in the list.
Right. Of course, it covers. It's a residuary.
Everything.
Yeah. So you have to take the concurrence of the state.
Yes.
Now, suppose it is not covered by B2 in the sense that there is no concurrence of the state. Right? It's not covered by B1.
Yes.
And you have not taken the concurrence of the state under B2.
Correct.
On such an aspect, the state legislature cannot exercise power because it's not in the state list. One second.
Residuary power of the state.
1 second.
Residuary power of the
1
state.
second.
Yeah.
The state legislature, the state legislature is operating on the state list.
And residuary power, Mullah.
Residuary power came in and when? Under what?
Other way around, Mullah.
No,
Kashmir, it was there from the beginning.
Where does the residuary power find?
Yes, I'll show that to you, Lord. This is part of the instrument itself.
Instrument of accession.
Yes, it is part of Mullah's all orders of the government.
No, but has specifically there's
it's also part of the constitution. I'll show
I
that.
just wanted to see whether it's part.
Yes. Your government should take it, Mullah.
Because otherwise there'll be a peculiar situation.
Yes.
Where neither parliament can exercise power, nor
show,
can the state legislature
I
exercise
take
power.
your lordship's point. I will demonstrate to your lordships that the residuary power was with the state legislature throughout and with the state government throughout. That was the condition on which, Mullah, the accession took place. And I will demonstrate that to your lordship. That's
Mr. Sibyl,
that's the least of my problems.
Mr. Sibyl, slightly different.
Okay. Yes. Yes.
Which is very different from what is subject matter of 1 and 2.
Yes, right.
Because they do not deal with abrogation of the article.
Absolutely. Right. Yes, absolutely. Your lordship is right.
And therefore, when we read at that power, which is specifically conferred on the president, then proviso, leave aside for the time being the proviso. Do you agree with that interpretation?
No, I
don't. For the time being, just leave the proviso.
I can't read the constitution in this fashion. I can't even read an act in that fashion. Let's forget the constitution. How do I leave the proviso when the constitution is staring us in the face?
No. The question was,
is putting to
therefore, clause 3 deals with abrogation of the article itself, which is not the subject matter of 1 and 2.
No, it's subject matter of C. Article 1 shall apply to the state.
No, correct. But it deals with complete abrogation of the article itself.
I agree.
And in that context, you may argue that your argument at the first fold was, it will be only if the conditions of the proviso is satisfied, that clause 3 will apply. Otherwise, if the conditions of the proviso are not satisfied, clause 3 will not apply.
That's how your lordships have interpreted proviso since 1950, Mullah. That's all that I can say. I can't say more than that.
A proviso may in some cases be an exception. A proviso may in some cases be an elaboration.
There's a difference, Mullah. Yes.
It depends upon the nature of the...
provisos are sometimes change colors.
Proviso, Mullah. Proviso that the recommendation...
rule for a proviso in that sense.
Provided that the recommendation of the legislative, of the Constituent Assembly shall be necessary It's a restriction on the exercise of power. That's right. Referred to in clause 2, Malaj.
Strict way to interpret clause 3 to say that the power existed and then will vanish once the Constitutional Assembly of the state is no longer exists.
Well, but you kindly read 2, Malaj. If the concurrence of the government of the state referred to in para 2, subclause B of 1 or the second proviso to D of that clause be given before the Constituent Assembly for the purpose of framing of the Constitution that's the purpose.
Mr. Sibal, you have contradicted yourself. When you refer to clause C, subclause C is an independent clause and clause D not applicable to clause C.
No,
Then
what
the
I'm
second
saying is,
proviso will not apply.
in both cases,
And therefore only subclause 3 will apply.
Malaj, point is clause 2 says that
Clause 3 will apply.
even for the purposes of those notifications.
Anyway, we'll examine that.
Yes.
We have understood your line of argument.
No, there is something that's missing, Malaj. The proviso says, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2. Why are they saying that, Malaj? The purpose is given in clause 2. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary for the president before the president issues such a notification. It is necessary and before he issues it. How can you say that it's explanatory or that it's an independent clause? It specifies how it is to happen. It has to happen before. That is, the permission has to have before.
You know, the reason why clause 3 refers to the Constituent Assembly of the state referred to in clause 2 is because clause 2 refers to the Constituent Assembly for the purpose of framing the Constitution.
That's correct. That's exactly
Right? That's your point. You get that point?
Yeah.
Now, therefore, the recommendation of which Constituent Assembly, this makes it very clear that one and only Constituent Assembly which was formed for the purpose of framing of the state constitution.
Right.
Once the frame of the constitution was done, then that purpose of the Constituent Assembly is not like a permanent body. Like Parliament is a permanent body, the Supreme Court is a permanent body.
No doubt about it.
It's a body which has a specific purpose and then after it becomes functus officio, so to speak.
Right.
Therefore, once the Constituent Assembly had fulfilled its purpose, then the proviso itself has no application.
No, this is the problem, Malaj, with the problem there is when you are applying 3 without the proviso and saying this is a blanket power, then Malaj, the president can do it anytime without any consultation.
Also, Mr. Sibal, one thing which we must
just passes an order.
Mr.
That
Sibal,
I integrate. That's
one thing which we have to also bear in mind is all these provisions are in Part 21. Part 21 has used 3 expressions: temporary, transitional, and special.
Correct.
Temporary provisions are those which are intended to be in existence for a limited period of time,
That's right.
but without a point of terminus, right? A temporary government servant. That person is temporary for a limited period of time, but whose services are to be terminated. Until you are terminating the services of that person still continues.
Right.
That's that broad concept, of temporary.
Absolutely right.
Transitional means something which necessarily has a terminus.
That's right.
Laws made
earlier.
I'll show you some of the transitional provisions in this part.
Right.
And third is special.
Right.
Now we'll see, for instance, after 370, we'll get some idea from the provisions after 370. Say 371, special provision with respect to Maharashtra and Gujarat. 371A, special provision for Nagaland.
Yes.
Then we get 371B, special provision for Assam.
Correct.
371C, special provision for Manipur.
That's correct.
D, for the state of Andhra Pradesh and Telangana.
Right.
E, establishment of Central University in AP. F is special provision for Sikkim, which came in 75.
Right.
G, Mizoram. H, special provision for Arunachal.
Yes.
Then I for state of Goa. J for the state of Karnataka.
Right.
Now, after these special provisions end, we come to 372.
Right.
which continuance in force of
Existing laws.
existing laws,
Yes.
which then says, shall continue in force until altered or repealed or amended by a competent legislature
Right.
or by any other, like the penal code.
Right.
It just continued in force until it is altered. Then similarly, now we have 372A, power of the president to adapt laws.
Right.
And it says the president may by order made before the 1st of November 1957 make such adaptations and modifications.
Right.
So this was a transitional provision that the president had to make those adaptations by the 1st of November 1957. So it was a transitional provision. After that, the power lapses. So similarly, 373, was then came the provisions relating to the judges whose services had to be taken over by the Union of India, public service commissions, so on and so forth. And then 392, the power of the president to remove difficulties.
Right.
So therefore, part 21 basically covers special provisions, temporary provisions, and transitional provisions.
Right.
Now, it doesn't use the expression transitional in any head note or marginal note to the articles. But temporary and special are used in the marginal notes to specific articles of part 21. And 370 specifically uses the expression temporary.
It had to, Malad. It had to.
So, can we then, by saying that the power under clause 3 goes once the Constituent Assembly comes to an end, really convert this into a permanent provision, which it was never intended to be by the Constitution?
But that's, Malad, your lordships are now putting to me, it was never intended to be. In 370, when it was put in, it had to be a temporary provision. It had to be, Malad. There was nothing there at that point in time. It had to be, Malad. It could never be a permanent thing.
So why did the Constitution then put it in part 21?
Because, Malad, it is a separate, it relates to a particular state where the two sovereigns have come together and made a compact which is incorporated and integrated.
No, part 21 does not deal only with Kashmir. Doesn't deal only with Jammu and Kashmir. It deals with other states.
I'm sorry, I didn't get it.
Part 21
Yes.
does not deal only with Jammu and Kashmir.
No, of course not. That's why I think it's a separate, independent provision and has to be interpreted on its own terms. You can't incorporate Mallad's concepts outside of 370 and integrate them into 370 and say, this is how we'll read 370. Yes. 370 is not temporary. 370 is not temporary.
Penal note expressly says it's temporary.
No, it says temporary provisions with respect to temporary provisions. In other words, this is a provision which is temporary till such time as the Constituent Assembly decides this way or that way. That's the whole purpose, Malad. Because when the Constitution came into force, there was no such thing as the Constituent Assembly even. How did the Constitution add this here? Because there was an understanding. Otherwise, why would you bring in the term Constituent Assembly in 370? It was not anywhere else. Temporary, supposing, Malad, not that I should say so, because one never knows. Supposing the Constituent Assembly decided not to be with India, then what happens? We would have to do what we did to Junagadh.
There are two types of temporary provisions in part 21. One type is Article 369. 369 says Parliament had the power to make laws for a period of 5 years.
That's correct.
On certain matters, even if they may not be in the concurrent list.
Absolutely, yes.
So they were temporary with reference to time. They were temporal.
I agree.
Then 370 is an illustration of a case which is temporary in the sense it will operate till abrogated. Would it be? I mean, we just... When Mr.
Not till abrogated.
When we are putting your point, it's actually we are thinking that.
I understand.
We are just.
I understand, Malad. This is your lordships have always done this, Malad. Your lordships. This is a very fruitful debate because we all have to understand. Well, we are here standing
and it's only in that
India.
process that we can really.
For the people of India, we're not. Malad. This is not something that we believe we are totally integrated into India. That's not an issue, Malad. We have said so. Therefore, there is no. As far as. Our constitution says we are an integral part of India. So where's the question of are moving away from that. Yes, yes. Yes. Yeah. Yeah. There were only two choices, Manoj. We said, the constituency assembly said all of constitution to apply. We'd be like any other state.
But they don't have to make a constitution of their own.
Then they don't have to make a constitution of their own.
Indian constitution of best.
Once again, they don't have to make a constitution of their own. The Constituent Assembly would say, we integrate into India, we're part of India, we're like any other state, we don't need a constitution, and all those lists will apply. That power is there. So why was it called a temporary provision? Because that had to be decided by the Constituent Assembly. And then you interpret the terms to find out how that power is to be exercised. Because it was unlike any other state. The residuary power was always with the state. In the Delhi Agreement in 1952, I have a reached.
370 came in with the original constitution.
Yes.
But is there anything in the Constituent Assembly debates which throws
Yes.
lights on why they introduced it?
I'll do that straight away. Yes, I'll give your lordships that. Exactly what I'm saying is what they said.
Let us see the CAD.
Volume 8.
Volume 8.
Petition now.
This volume 8, huh? Yeah. Originally, I kindly see volume 8, PDF page 1173. It's okay, 1174 actually. Volume 8, PDF page 1174.
1174.
PDF 1174.
4034.
Running page 4035.
4035.
Yes, running page. But PDF 1174.
Volume 8.
Volume 8. By now we know your lordships elicit answers in order to find out what we wish to say. Not that your lordships have ever decided on one way or the other. We always do that, and I've seen
the last word is said in a matter,
Yes,
Mr.
exactly.
Sibal, everything is open.
When the printed word comes, that's the last word.
Yes, I always felt, Mr. Sibal, if the judge is very quiet, there is a problem.
That's a real problem. It's a real problem, which we face
Actually, Mr.
occasionally.
Sibal, there are times when you start dictating a judgment, you start dictating it with a certain...
And then you change your mind.
And you start dictating with a certain conclusion in mind, because that's what you have formed. When you start dictating it,
Yes.
then you realize that your line of reasoning is wrong, because, when you dictate, the logical syntax has to fall in place when, you are engaged with yourself. Then you realize, no, it's not going to fit in like this.
Quite frankly, Miller, and I'll be honest, when I looked at it myself, I asked this question that your lordships is asking me. I myself must ask that question.
4034, Mr.
Yes, 4035.
Oh, sorry, 1174, yes.
1174. Then kindly come to Mothers, the sentence starting. Sir, this matter, your lordship has that? They set out, Mothers.
Gopal Swami Iyengar?
Yes, Iyengar, Gopal Swami Iyengar.
Yes.
Then it says, sir, this matter, the matter of this particular motion relates to Jammu and Kashmir. The House is fully aware of the fact that the state has acceded to the dominion of India. The history of this accession is also well known. The accession took place on 26th October 1947. Since then, the state had a checkered history. Conditions are yet not normal. The meaning of this accession is that at present the state is a unit of a federal state, namely the Dominion of India. This dominion is getting transformed into a republic, which will be inaugurated on 26 January 1950. The Jammu and Kashmir state, therefore, has to become a unit of the new Republic of India. As the House is aware, accession to the dominion always took place by means of an instrument which had to be signed by the ruler of the state and which had to be accepted by the Governor General of India. That has taken place in this case. As the House is also aware, instruments of accession are a thing of the past in the new constitution, will be a thing of the past in the new constitution. The states have been integrated with the Federal Republic in such manner that they do not have to accede or execute a document of accession for the purpose of becoming units of the Republic, but they are mentioned in the constitution itself. And in the case of practically all states other than the state of Jammu and Kashmir, their constitutions also have been embodied in the constitution for the whole of India. And all those other states have agreed to integrate themselves in that way and accept the constitution provided. The discrimination is due to the special, why this discrimination? That's the question asked. The discrimination is due to the special conditions of Kashmir. That particular state is not yet ripe for this kind of integration. It is the hope of everybody here that in due course, even Jammu and Kashmir will become ripe for the same sort of integration as has taken place in the case of other states. At present, it is not possible to achieve that integration. There are various reasons why this is not possible. Now, I shall refer again to this a little later. In the case of other Indian states or unions of states, there are 2 or 3 points which have got to be remembered. They've all accepted the constitution framed for states in part 1 of the new constitution. And those provisions have been adapted so as to suit conditions of Indian states and union of states. Secondly, the center, that is the Republican Federal Center, will have power to make laws applying in every such state or union to all unions and concurrent subjects. Thirdly, a uniformity of relationship has been established between those states and unions and the center. Kashmir's conditions are, as I have said, special and require special treatment. I do not want to take much time of the House, but I shall briefly indicate the special conditions are. In the first place, there has been a war going on within the limits of Jammu and Kashmir. There was a ceasefire agreed to at the beginning of this year, and that ceasefire is still on, but the conditions in the state are still unusual and abnormal. They have not settled down. It is therefore necessary that the administration of the state should be geared to these unusual conditions until normal life is restored. Part of the state is still in the hands of rebels. We are entangled with the United Nations in regard to Jammu and Kashmir, and it is not possible to say now when we shall be free from this entanglement. That can take place only when Kashmir problem is satisfactorily settled. Again, the government of India have committed themselves to the people of Kashmir in certain respects. They have committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with the republic or wish to go out of it. We are also committed to ascertaining the will of the people by means of a plebiscite, provided that peaceful and normal conditions are restored and the impartiality of the plebiscite. This is not relevant anymore.
Next sentence. Next sentence.
Next sentence, but this is not relevant. Plebiscite issue is not relevant.
That is not relevant as per your comment. Even the part before that.
Yes, now see further, Malad. We have also agreed that the will of the people, through the instrument of a constituent assembly, will determine the constitution of the state as well as the sphere of union jurisdiction of the state. That's why it was a temporary provision. Now, next paragraph. At present, the legislature, which was known as the Praja Sabha in the state, is dead. Neither that legislature nor a constituent assembly can be convoked or can function until complete peace comes to prevail in the state. We've therefore to deal with the government of the state, which, as represented in its Council of Ministers, reflects the opinion of the largest political party in the state. Till a constituent assembly comes into being, only an interim arrangement is possible, which is why it is temporary. and not an arrangement which could at once be brought into line with the arrangement that exists in the case of other states. This tells your lordships why it is temporary. Now, if you remember the viewpoints that I have mentioned, it is inevitable conclusion that at the present moment we could establish only an interim system. Article 306A as, now what is 306A? 370. Is an attempt to establish such a system. Interim till the Constituent Assembly decides. I shall now proceed, whether that's not relevant. So clearly, it gives you an indication why it was interim. It gives you an indication why it was temporary. Because there was nothing in place. Legislature was not working, Constituent Assembly was not in place, and the will of the people had to be taken, which was reflected in the Constituent Assembly. Therefore, it was temporary. And therefore, 370, now remember this, when 370 is enacted in 1950, at that point in time, nothing is in place. And yet in 373, they say, you will have to get the recommendation of the Constituent Assembly. That is, dehors the Constituent Assembly having been formed. Dehors its constitution. Why would the Constitution say that? Then kindly come to 4039. Second paragraph of 4039. Yes, that's. Now it's very interesting with it. Well, let's read the paragraph, then we come to clause 2. First that, and then I'll read the other paragraph. Then we come to clause 2. My lords have that? That's PDF 1178. 4039. That's right.
Justice called them.
No, Malas, actually, maybe Malas, I should start with volume 8, 1176. Let's take 1176. PDF 1176. Running page 4037.
Read the whole thing.
Yeah, I'll read the whole thing.
Because it will be the interpretation they asked you before lunch.
Most of your lordship's questions, Malas, hopefully are answered in this. There's the second portion of this article, 1076, Malas.
He hasn't got it.
Yes. He says, Malas, I shall now proceed to, Lordship has that paragraph, I shall now proceed to take the House through the provisions of this article. That's 306A, which is 370. As honorable members will remember, the Constitution of Indian States is mainly governed by Article 211A of this Constitution, which applies to the Constitution to Indian States, the Constitution of Indian States, subject to the modifications contained in Part 6A, read with the schedule. So far as that provision is concerned, I've already indicated to you that the provisions regarding the Constitution of other states could not at present be applied to Jammu and Kashmir. Therefore, Clause 1 of A of this article says that the provisions of 211A of his Constitution shall not apply to the state of Jammu and Kashmir. That's 238, Malas. 211A is 238A.
Now B.
The second portion of this article relates to the legislative authority of Parliament. So, Parliament may by law. That's B. Over the state of Jammu and Kashmir. This is governed primarily by the instrument of accession. Broadly speaking, that legislative power is confined to the three subjects of defense, foreign affairs and communications. But as a matter of fact, these broad categories include a number of items which are listed in the instrument of accession. I believe they include, I believe they number some 20 to 25. Now, these items have undergone a change in description, in numbering, in arrangement, as amongst themselves in List 1 and List 3 of the new Constitution. It is therefore necessary that the items mentioned in the instrument of accession should be brought in line with the changed designations of entries in the lists 1 and 3 of the new Constitution. So, Clause 1B of 306A says that this listing of items as per the terms of the new Constitution should be done by the President in consultation with the government of the state. That explains, Manoj. B1. Clause B2 refers to possible additions to the list in the instrument of accession, and these additions could be made according to the provisions of this article with the concurrence of the government of the state. The idea is that even before the Constituent Assembly meets, it may be necessary in the interest of both the center and the state that certain items which are not included in the instrument of accession would be appropriately added to the list in that instrument so that administration, legislation, and executive action might be furthered. And as this may happen before the Constituent Assembly meets, the only authority from whom we can get consent for the addition in the government of the state that is provided for. Then there is the explanation, which defines what the government of the state means. The government of the state is defined both in the Constitution, which is now supposed to be in the force in Jammu and Kashmir, the state, as well as the proclamation with the Maharaja issued on 5th March 1948, the terms of which are as follows. Then kindly come to C and D. Yes, second last paragraph in 1177, PDF 1177. 4038. My lord has that. Clause C and D refer to the provisions of the Constitution other than matters listed in 1 and 3. These various provisions have been divided into certain categories. The first, according to this draft, is that Article 1 of the Constitution will automatically apply. As you know, it describes the territory of India and includes among those territories all the states mentioned in Part 3, and Jammu and Kashmir is one of the states mentioned in Part 3. With regard to the other provisions in the Constitution, these will apply to the Jammu and Kashmir state with such exceptions and modifications as may be decided on when the President issues an order to that effect. The order can be issued...
Just read the sentence once again. With regard to other provisions of the Constitution,
Yes.
these will apply when the President issues an order to that effect.
Yes.
That order can be issued with regard to subjects mentioned in the instrument of accession only after consultation with the government of the state.
Yes.
With
Correct.
regard to other matters, concurrence of the government has to be taken.
That's B1 and B2, Madam. Two provisos, B1 and B2. That order can be issued in regard to subjects mentioned in the instrument only after consultation. In regard to the others, it concurs. Now, it is not the case, nor is it the contention of the members of Kashmir government, whom I took opportunity of consulting before this draft was finalized. It's not their intention that the other provisions of the
case. No.
Sorry. That's right. Now, it is not the case, nor is it the intention of the members of the Kashmir government, whom I took the opportunity of consulting before this draft was finalized. It's not their intention that the other provisions of the Constitution are not to apply. That particular point of view is that these provisions would apply only in cases where they can suitably apply and only subject to such modifications or exceptions as the particular conditions of Jammu and Kashmir may require. I wish to say that no more about that particular point at the present moment. Then we come to clause 2. You will remember that several of these clauses provide for concurrence of the government of Jammu and Kashmir state. Now, these relate particularly to matters not mentioned in the instrument of accession. And it is one of our commitments to the people and government of Kashmir that no such additions should be made except with the consent of the Constituent Assembly, which may be called in the state for the purpose of framing its constitution. In other words, what we are committed to is that these additions are matters for determination by the Constituent Assembly of the state. This is commitment. Now you will recall that in some of the clauses of this article, we have provided for concurrence of the government of the state. The government of the state feel that in view of the commitments already entered between the state and the center, they cannot be regarded as final authorities for the giving of this concurrence, though they are prepared to give it in the interim periods. But if they do not give this concurrence, this clause, if they do give this concurrence, the clause provides that that concurrence should be placed before the Constituent Assembly when it meets, and the Constituent Assembly will take whatever decisions it likes to take. What can be clearer than this? The last clause refers to what may happen later on, which is why it's temporary.
So the paragraph which you read is with reference to clause 2, not with reference to clause 3.
Yes, I'm not saying that. I am just reading.
The last clause is clause 3.
I'm saying I'm reading it holistically so you know why it is called temporary.
2 and 3 are temporary.
2 and 3 are temporary, no doubt about it, because they have to be actually agreed upon by the legislature, by the Constituent Assembly. Now C3. The last clause refers to what may happen later on. We have said Article 211A, which is 238A, will not apply to Jammu and Kashmir, but that cannot be a permanent feature of the Constitution of the state, and hope it will not be. So the provision is made that when the Constituent Assembly of the state has met and taken its decision, both on the Constitution for that state and on the range of federal jurisdiction over the state, the President may, on the recommendation of the Constituent Assembly, issue an order that this Article 306A shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. But before he issues any order of that kind, the recommendation of the Constituent Assembly will be a condition precedent. That explains the whole of the article. Well, there can be nothing clearer than this. I mean, we in hindsight, sitting in 2023, can't interpret a provision except on its terms. We're here to interpret the Constitution. We're not here to legitimize a process which is inconsistent with the express terms of the Constitution. Next paragraph. The effect of this article is that the Jammu and Kashmir state, which is now a part of India, will continue to be a part of India, will be a unit of the future Federal Republic of India, and the Union Legislature will get jurisdiction to enact laws on matters specified either in the instrument of accession or by later addition with the concurrence of the government of the state, and steps have to be taken for the purpose of convening a Constituent Assembly in due course, which will go into the matters I have already referred to. When it comes to a decision on the different matters, it will make a recommendation to the President, who will either abrogate 306A or direct that it shall apply with such modifications and exceptions as the Constituent Assembly may recommend. That, sir, is briefly a description of the effect of this article, and I hope the House will carry it. This explains several things. One, why it was a temporary provision. Two, Constituent Assembly had not been constituted then. It was envisaged in our Constitution that it will be constituted. And the ultimate authority of abrogating 370 will be left to the Constituent Assembly. And a precondition of that would be a recommendation of the Constituent Assembly for the President to pass an order. Absent that, it can't be done. That was the understanding of the lawmakers, of the constitution makers of India, of the Constituent Assembly. That is why it was put in. It was not a temporary provision in the sense that it had ultimately 370 had to be abrogated. That's not the meaning of the temporary provision that we're talking about. In any case, Malaj, a heading of an article can determine the content of the article. Content of the article is clear. So, Malaj, the government of the day was staring at the provisions of Article 370. And according to me, through a political act, not a constitutional procedure, declared that 370 is gone. That's why I said it was tossed out of the window through a political act, not through a constitutional act. Such a political act cannot be determined by the Parliament of India. It's not in the remit of the Parliament of India to take a political decision to abrogate 370. And I will demonstrate as we move along, Malaj, how it was done and in what manner it was done. Nobody can deny that the people of Jammu and Kashmir are with the Union. It's an integral part. Nobody can deny that. But there is a special relationship. There is a unique relationship which is engrafted in 370 itself. You can't jettison that except by following a process which is ordained by law. So, as your lordships asked me on the constitution, I wanted to just mention this. This is the debate. Amarnath.
Times that. One second. Okay.
And I just want to mention that all the amendments sought, Malas, were all rejected and withdrawn.
Not moved.
Not moved.
Mr. Mahavir, he did not move those amendments.
Yes, sir. So, Malas, may I go back to the list of dates now that I've, Malas, put my position on Article 370 straight away. Well, Lordship, let's go back to the list of dates, Malas, and finish. Malas, kindly come to my written submissions, volume 2, and the PDF page is 41. Same page that I left.
We are on the list of dates and the serial where you left.
Yes, ma'am. That's right. Well, of course, unless we have a clear picture of 370, but it will be difficult to. Item 33 at page PDF 41. My lords have that? Justice. So we can't.
Yes.
Under 370 sub-article 1 of the Constitution and following consultation with the government of Jammu and Kashmir, the President issued the Constitution Application of Jammu Kashmir Amendment Order 39, modifying Articles 54, 55 of the Constitution, as long as they applied to state of Jammu and Kashmir. Now, as your lordships will notice, each of these orders were issued under B1. D1, all of these orders.
B1.
D1.
D1.
All of these orders. Then in 1952, on the 10th of June, whereas on June 10, 52, the Basic Principles of Committee of Jammu and Kashmir Constituent Assembly submitted its interim report to the Jammu and Kashmir Constituent Assembly and recommended that the form of the future Constitution of Jammu and Kashmir shall be wholly democratic. The institution of hereditary rulership shall be terminated. The office of the head of state shall be elective. Then the next is very important. In 1952, the Delhi Agreement of 1952 was entered into between the Government of India and the Government of Jammu and Kashmir. Under this agreement, the Government of India agreed that while residuary powers of the legislature vested in Parliament in respect of other states, in the case of Jammu and Kashmir, such powers vested in the state itself. This is what my lord asked me the question. Now, let us kindly read this document. It's very important. Volume 1 of the compilation of documents, pages 13, PDF 13. 1 second. Yes. 1 second. Worship has that? The Delhi Agreement, 1952. Surikant has that. This is Malad's page 13, PDF 13.
This doesn't seem to be the main agreement. This seems to be some summary of the features of the agreement.
Yes, yes.
It's a summary of what are perceived.
What happened, what the features are.
Where is this summary taken from? Because the authenticity will depend on that.
The very next page is there, Madhur, I believe. This is Sheikh Muhammad Abdullah's statement to the Constituent Assembly on the Delhi Agreement on 11th August 1952. That's at PDF 16.
That's the actual extract.
Yes. I can read that, Madhur. I can read that. That's not the original either. I'll get you the original, Madhur. They'll have it in any case. What? Yes. That's the extract from the original. Are you sure? What is that page? 13 is an extract of the original. Summary of
summary, actually.
Main features of this agreement.
Page 16 is the extract. Page 16.
Page 16 is actually just is a Sheikh Muhammad Abdullah's statement to the Constituent Assembly.
Of the statement, yes. Yeah.
Yes.
Can I read the summary, Mother? That this is not something that. that will be
You want to read the summary?
controverted seriously. Says that in view of the uniform and consistent stand taken by the Jammu and Kashmir Constituent Assembly, the sovereignty in all matters other than those specified in the instrument of accession continues to reside in the state. The Government of India agreed that while the residuary powers of the legislature vested in the centre in respect of all states other than Jammu and Kashmir, in the case of the latter, they vested in the state itself. It was agreed between the two governments that in accordance with Article 5 of the Indian Constitution, persons who have their domicile, we're not concerned with so much, with the domicile issue. And I can read it. That the two governments that in accordance with Article 5, persons who have their domicile in Jammu and Kashmir shall be regarded as citizens of India.
State subject, Sybil, may not be directly relevant.
That's why I said, Malad. Then, Malad, 4 is the union government agreed that the state should have its own flag in addition to the union flag. But it was agreed that the state government, that the state flag would not be a rival to the union. It was also recognized the union. Leave that out.
House other asset has to be like
that's right, that also. Then small Roman 6.
Yeah.
With regard to the fundamental rights, some basic principles agreed between the parties were enunciated. It was accepted that the people of the states were to have their fundamental rights. But in view of the peculiar position in which the state was placed, the whole chapter relating to fundamental rights of the Indian Constitution could not be made applicable to the state. The question which remained to be determined was whether the chapter on fundamental rights should form a part of the state constitution of the Constitution of India as applicable to the state. So it was not much as applied at that time, fully. With regard to the jurisdiction, let's leave that out on the Supreme Court. And then, there was a great deal of discussion, item 8. With regard to the emergency powers, the Government of India insisted on the application of Article 352, empowering the President to proclaim a general emergency in the state. State government argued that in the exercise of its powers over defense, item 1 of the union list, in the event of war or external aggression, the government would have full authority to take steps and proclaim emergency. But the state delegation was, however, averse to President exercising the power to proclaim a general emergency on account of internal disturbance, which ultimately your Lordship knows was also taken out of the Indian Constitution under 352.
At the relevant time, it was there.
It was there at the relevant time, but the state said we will not allow it to be exercised.
I'm just trying to think aloud. At the relevant time in 75.
Yes, it was there.
It was there.
It was very much there.
And this, through some subsequent orders, it equally applied to Jammu Kashmir at that time.
That's correct. That's correct. Absolutely right.
This summary which my friend was doing, Delhi Agreement summary, this seems to have been taken out of this book, and Justice A.S. Anand.
It's not publicly available, but Justice Anand has that one.
Constitution, it's published. Constitution
No. The agreement is not publicly available.
So he has given the authoritative statement in the sense, what is it? What does it imply?
That's correct. This is also part of the compilation, which is before your law.
Yes.
Justice
That's what we
Anand.
were reading.
Yes. 10 minutes. In order to meet the viewpoint of the state delegation, Government of India agreed to the modification of 352 in its application to Kashmir by the addition of the following words, but in regard to internal disturbance of the request or with the concurrence of the government of the state. That's how it. But the parties agreed that the application of 356, dealing with suspension of the state constitution, and 360, dealing with financial emergency, was not necessary. Right. Then Sheikh Abdullah's statement to the Constituent Assembly on 11th August. I crave permission to make a statement before the House in regard to the constitutional relationship with Jammu Kashmir and the Indian Union. As the honourable members are aware, during the last session of the Constituent Assembly, the Basic Principles Committee had submitted a report making certain specific recommendations about the future head of the state. House, while accepting these recommendations, had charged the drafting committee to present for the consideration of the Assembly a draft resolution incorporating the proposed principles for the election of the head of state. Drafting committee will no doubt submit its report to the House. Since the changes proposed in the Assembly involve corresponding adjustments in the Indian Constitution, Government of India desired that it should have time to discuss with our representatives other matters pertaining to the constitutional relationship of our state. with the Union. During the last stage of these discussions, it became necessary for me and some of my other colleagues in the government to participate in the talks. I'm now in a position to inform the House that certain broad principles have been laid down and certain decisions have been tentatively arrived at between the two governments. The basis of our relationship with India is the instrument of accession, which enabled our state to enter into a union with India. In accordance with the terms of the instrument, certain powers were transferred to the centre. The principal matters specified to the purpose in respect to which the Dominion legislature could make laws for the state were. This arrangement involved a division of sovereignty, which is the normal feature of a federation. Beyond the powers transferred to the Union, the state enjoyed complete residuary sovereignty. That's why, Malas, when you read 370, you can't read into it, Malas, other matters. These terms of the association of our state with the Dominion were maintained, and subsequently, when the Constituent Assembly of India was charged with the task of framing a constitution, this overriding consideration was kept in view in determining the position of this state in the proposed constitution. Earlier to this, it had been agreed between the two governments that in view of the special problems arising in respect of this state and the fact that the government of India have assured its people they would themselves finally determine their political future, a special position should be accorded to Jammu and Kashmir in the future constitution so that a limited field of the union powers over the state is ensured. Our representatives were nominated by the Jammu and Kashmir state to the Constituent Assembly of India. These representatives participated in the deliberations of the Assembly in India at a time when the bulk of the Indian Constitution had already been adopted. It was at this stage that the constitutional position of this state was determined in the Constitution of India. This is very important. It was in a collaborative exercise, a dialogue. It was not behind the back of the Union of India or anything like that. They knew what was to happen in the future. Representatives of Jammu and Kashmir reiterated their view that our association with India should be based on the terms of the instrument of accession. It was at this stage that the constitutional position was determined. The representatives of the Jammu Kashmir state reiterated their view that an association with India should be based on the terms of the instrument of accession. It was also made clear that while the accession of Jammu and Kashmir state with India was complete, in fact and law, to the extent of the subjects enumerated in this instrument, the autonomy of the state with regard to all other subjects outside the ambit of the instrument of accession should be preserved. Events a good deal of confused thinking and uninformed criticism is indulged in some interested people. I would like to point out that the Constitution has confined the scope and jurisdiction of the Union powers to the terms of the instrument of accession, with a proviso that they may be extended to such other matters as the President may by order specify with the concurrence of the Jammu and Kashmir Assembly. This is the concurrent list matters. The special problems facing the state were thus taken into account, and under the Constitution, the relationship approximated to that subsisting under the instrument of accession. The Constitution of India, of the Indian Union, therefore clearly envisaged the convening of a Constituent Assembly for the Jammu and Kashmir state, which would be finally competent to determine the ultimate position of the state in respect of the sphere of its accession, which would be incorporated as in the shape of permanent provisions of the Constitution. That's why temporal. But the rest really need not trouble your lordships. I need not trouble your lordships. Then, but it's rigidity powers, it's important. Page 19, PDF 19. There is a heading of residuary powers. It was agreed that while under the present Indian Constitution, the residuary powers vested in the centre in respect of all the states other than Jammu and Kashmir, in the case of our state, they vested in the state itself. This position is compatible with Article 370 of the Constitution of India and the instrument of accession on which this article is based. We've always held that the ultimate source of sovereignty resides in the people. It is therefore from the people that all powers can flow. Under these circumstances, it is up to the people of Kashmir through this assembly to transfer more powers of mutual advantage to the custody of the Union. So, but what happens ultimately, and I'm just, since I will come to that later, is that Parliament exercised the will of the people of Jammu and Kashmir. when they abrogated the article. That's what happened. They took upon themselves the constitutional responsibility of saying that we are now the legislature. We are the Constituent Assembly. And we will exercise the will of the people of state of Jammu and Kashmir to say that we abrogate 370. In essence, that's what happened. Is that possible constitutionally? Is that envisaged by 370? Is this not an exercise of political power? Without reference to 370? And can such a power be exercised in the manner in which it was exercised? That's a matter of procedure. Well, then there is citizenship, we need not go into it, fundamental rights, we don't have to go into all this. Let us now kindly come to list of dates again. Right, back at 42 months. Item 37. Article 370, sub-article 3. The PDF, Madam, 42. Hello, Justice Kawai has it?
Yes, but is well.
Yes. Under I just was wondering whether all of your lordships had it. I have to say, Mother, that I've been and even though I say it to myself, a good student because I can access it immediately.
This is my second constitution where
I
see the Chief Justice who's made me take to this.
No, Mother, I done. My Lord said to me, I'm not going to allow you to argue on your... So I had to learn.
Yes.
37 minutes. Under Article 370, sub-Article 3 of the Constitution, the President, after a recommendation of the J&K Assembly, issued Notification 44, modifying 370, to include an explanation that the phrase state government meant the Sadr-e Riyasat acting in aid and advice of the Council. Kindly note that. That was done by the Constituent Assembly. That's the only time unless they exercise their powers. With reference to 370. On 14th of May 1954, with the concurrence of the government of Jammu and Kashmir, the President issued the Constitution Adaptation to Jammu Kashmir Order 1954, which came into force on May 14, 1954. This order superseded the Constitution application to Jammu Kashmir Order of 1950, which had only those limited provisions. Paragraph 2 of the said order set those provisions of the Constitution, which in addition to Articles 1 and 370, because that order only had Articles 1 and 370, would be applicable, and other than one, would be applicable to the state of Jammu and Kashmir. Notably, a second proviso was introduced into Article 3 as applied to the state of Jammu and Kashmir in the following terms, provided that no bill providing for increasing or diminishing the area, this is also very important, of the state of Jammu Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. So your Lordship knows, Mothers, Article 3, they can change the boundaries. What happened in this case was, not that they changed the boundaries, Mothers, they converted it into a union territory, which is the other problematic issue, which of course we'll have to argue later. You can change the boundaries of a state, you can bifurcate the boundaries of a large state into smaller states, but never in the history of this country has a state been converted into a union territory.
You can carve out a union territory out of a state.
You can carve out, but you can't have all of Madhya Pradesh being a union territory tomorrow.
understanding some assurance that on assembly elections being held, Jammu and Kashmir will be a state. Or
No,
I read it
that's
somewhere.
true. But what they have converted it into a union territory as of now. I mean, that's unthinkable. And under the article for Jammu and Kashmir, there was a special provision that had to be consented to. That was also not done. So, Malas, you move away from representative democracy, convert it into a union territory under your direct rule. You do away with representative democracy, and 5 years have passed. And every day we hear that we are going to soon have elections. But there has to be a constitutional basis for doing this, Malas. And kindly note one thing. In May 2019, there were parliamentary elections in the state of Jammu and Kashmir. In 2019, May, 3 months after this. This happened on the 6th of August, September, October, November, December, May. You have parliamentary elections. So you can hold parliamentary elections, but you will not hold state elections. But I'm moving away from that to another issue altogether. So, Malas, then 1039, 1711-1956, the Constituent Assembly of Jammu and Kashmir, in exercise of its constituent powers, approved and adopted the Constitution of Jammu and Kashmir. Which is why I started off with the proposition that the concept of a Constituent Assembly is a political exercise. That political authority, that political body can decide on the future of the state. Could have decided on the future of the state. But that's a political decision. You want to abrogate 370, abrogate 370. You want to go integrate into India completely, say we don't need a constitution. But that's a political act. That political act cannot be exercised by parliament, by a legislative body. Because that legislative body is controlled by the Constitution. And its functions are controlled by the Constitution. It can't go beyond that. Which is why I made that statement in the beginning. Then verse 40, the Constitution of Jammu and Kashmir 1957 came into force on January 26, 1957. By means of this Constitution, the people of the state of Jammu and Kashmir, having solemnly resolved in the presence of the accession of this state of India, which took place on 26th day of October 1947, to further define the existing relationship of the state with the Union of India as an integral part thereof. That's declared in the Constitution. So nobody can question that. Nobody need question that. Nobody can say that we are not being regarded as, we were not saying that we are not an integral part of India.
Article 1 applies.
Article 1 applies. And the Constitution defined that relationship. And having defined that relationship, you can't just jettison it. Section 5 of the Constitution of Jammu and Kashmir provided that the legislative power of the state extended to all matters except those with respect to which Parliament had power to make laws for the state under the Constitution of India as applicable. Applicable to the state of Jammu and Kashmir. Legislative powers in the state were to lie with the Legislative Assembly and the Legislative Council. Significantly, Section 147, which dealt with amendments to the Constitution of Jammu and Kashmir, provided that no bill or amendment seeking to change the provisions of the Constitution of India as they applied to Jammu and Kashmir would be introduced or moved in either of the state legislatures. They had no authority once the Constitution had come into force and the orders passed. Then on 21/11/1964, the Constitution application to Jammu Kashmir Third Amendment Order of 1964, that is CO 71, which amended the 54 order, made Article 356 applicable to the state with one modification, that the expression included the Constitution, excluded the Constitution of Jammu and Kashmir. Included, yes, included the Constitution of Jammu and Kashmir.
Those are there in all which have been passed.
I'll have a list.
You can just give the list.
Volume 3, you have all the orders.
This, you have now made your point on this. So all the orders.
I'm not asking your lordship to go through. I'm not even going to read it, Manas. Yeah.
53.
Yeah. We're not going to go into all this.
54, about 54 orders.
54 orders are there, around 54 orders.
Of the.
Yes, yes.
Database.
Of course, of the assembly.
No, some government.
Section.
The government, Manas.
Under D or under.
D. D1.
Not, no, B2 or B2 or B1, D.
D2, Manas.
D2.
D1.
The D only has one,
Just D,
the
Manas.
proviso.
It's just D.
D
Yeah.
doesn't have a number 2 or.
And most of them are amendments of the 54 order, Manas. 50 order, 54 order, and then amendments to the 54 order. That's what it is. Two. Yeah, but is it necessary? My lord is saying. That out. Item 43.
Yes.
The lordships don't mind, it's PDF 44. The Kashmir Accord, now that's a political document. (1975) was entered into, my lords have it. PDF 44. The Kashmir Accord 75 was entered into between the Government of India and the Government of Jammu and Kashmir. Under Clause 1 of the Accord, the relationship of the state of Jammu and Kashmir with the Union was to continue to be governed by Article 370 of the Constitution. Now kindly note, Madhaj, the temporary provision was over. Still be governed.
Why was this required to say it is to be governed if it is a permanent feature?
Sorry?
Why was there a requirement 27 to say this will continue to govern when it was a permanent feature?
Mullah, it also reiterated the residuary powers of the state. Mullah, that's not the only thing that happened. It's just a reiteration of the position that was accepted by the Government of India throughout, which is the constitutional position. After all, it's a political accord, Mullah. I mean, it has no legal basis that way, but it tells you of the intent of the signatories, Mullah.
Political change at that time.
Yes, I know that. Well, in any case, 75 is a momentous time in the history of this country. Yes. Luckily, I was out of the country, Mullah, so I...
The response to the Sheikh Abdullah settlement.
Yes, yes, yes. So, fine. Huh? And jail for ultimately 14 years. The background is, Malas, that whenever he came out, he was saying that, no, no, give us autonomy, give us autonomy. It is in that context that the accord was there, that you can't get out of 370. That's really the background to it. He was put in jail even by Mrs. Gandhi. So, Malas, the rest of the list of dates, kindly now see, come to straight to PDF 47. On 29th of March 2017. Then, of course, the clamoring began, remove 370, do away with 370. But that's a separate issue. I mean, we're not concerned with that. So
You are on 55 now?
55, exactly, man. Well, Lord Justice Khanna has 55. Justice Gawai. That's Suryakant. Yes. Member of Parliament Ratna Denag raised a question whether the Minister of Law and Justice, as to whether the government proposes to amend and remove 370 related to Jammu and Kashmir in the near future. If so, details thereof, if not the reason therefore, whether this will help in providing equitable justice to the people of the state, and if so, the details thereof. Minister of State and Law and Justice, so and so. At present, there is no such proposal under consideration.
These are only proposals.
These are only proposals, all no throughout. It goes on, Malik.
Yes.
Then 57 is Malad's section 92. This is important. Item 57. Section 92 of the Constitution of Jammu and Kashmir deals with provisions in case of a failure of the constitutional machinery in the state. Provision permitted the governor to, by proclamation, assume to himself all the powers and functions of the government of the state. Such a proclamation would, in terms of 92(5), require the concurrence of the President of India. Under 1923, would cease to operate 6 months after it was issued. On June 20, 2018, the governor, with the concurrence of the President, issued a proclamation under 92, declaring governor's rule in the state. This is important. Now we're coming to the present controversy. We can do it tomorrow, Madam.
We can then continue tomorrow.
Deeply obliged.